Call the list.
My lord, may I mention item number 8, my lord? Today it is fixed at 2 p.m.
Yes.
My lord, kindly take it upon tomorrow at 2 p.m. my lord.
Today I mentioned this matter. In that case, you will also extend the interim order.
In that event, my lord, your lordship may extend for a limited period for 7 days, or your lordship may take up the matter any day next week at 2 p.m. my lord.
So this matter, this matter can be taken up now.
No, my lord.
This is for extension of
This is
interim
for-
order. The interim order is going to be expired today. My learned friend saying he has some difficulty.
So can I take up this matter now?
No, my
That's
lord.
what I'm asking.
It is fixed at 2
Extension
p.m.
করে
right?
next week রাখতে বলছেন? His submission is that interim order may be extended and
For a limited period, my lord, matter will be taken up any day next week.
That's why this
At
matter
two-
has
at
to
2
be taken
PM,
up
my
now.
My lord, Mr. Dotto is leading
now
me
means extension.
Hmm?
Only extension for limited
Oh,
period.
for a limited period.
Yes. What do you want? Shall I take this matter now?
No, my lord.
Not for hearing, sir.
Not for hearing.
Only for extension.
Only for
of
extension.
only
Can
for
I?
extension? Yes.
Okay. Give me the item number 8.
8. কল হয়ে গেছে কোথায় আসেনি দাদা আসেনি
Diary. August 12th. 12th August.
গাজন করতে হবে না না নিশ্চয়ই
ঠিক আছে দেখেন 12th of August,
Yes,
2
my lord.
p.m. 12th of August.
My lord, can it be possible next week, my lord?
Next week,
Any day next week at 2 p.m. my lord. Any
2
day.
p.m. there are 3 matters, 4 matters like that. How can we take up these matters?
That will not be called on, then again I have to extension.
Again, there would be. I can fix the matter. Whether it is possible to hearing or not, that is the question.
12th August at 2 p.m.
12th August at 2 p.m. It will be the first matter. That's why I'm taking this matter on that day.
Leave no place.
Very good.
And interim order.
Please take down. Yes. Learned counsels appearing on behalf of the parties consented to fix the matter on 12th of August 2025 for hearing. Full stop. Let the matter appear in the list on 12th of August 2025 at 2 p.m. as a specially fixed matter. Full stop. Let the interim order passed by this court on the earlier occasion is further extended till 19th of August 2025 or until further, whichever is earlier.
Get
Lordship, for item number 2 today, Lordship, I appear for BPCL. Yesterday, Your Lordship, I'm led by Mr. Nag, Your Lordship. Yesterday, Mr. Nag could not conclude, but Your Lordship, Mr. Nag, due to some personal difficulties, stuck in some other court, Your Lordship. I'm praying for not today, Your Lordship. Or
Mr. Nag had concluded his submissions. I was making my reply.
Your Lordship, no, Your
I'd started making my reply.
Nag intends to
place some
submit
judgments and submit further, Your Lordship. Praying.
Nag has not
Concluded, Your Lordship.
not concluded. Yes.
so far 1, 3 and 4 is concerned, my lord, all submission has been called.
This matter I am hearing since yesterday.
Yes.
Let him start and
Uh,
now comes only the judge.
Your Lordship, praying for not today or fixing some other time, Your Lordship.
For 1, 3,
and 3 are over. 1, 2
Go
and
over.
3 are over.
over.
Only Mr.
I
Nag
want
matter
to
is
pass
pending.
the judgments, all the matters,
Yes.
order all the matters. That is the issues.
Yes,
I want to hear both the matters,
Sir,
both the matters.
Can you-
Mr. Nag says he will rely 1 or 2 judgment before your lordship.
Today, Mr. Nag is not available.
You are just outside the court.
Your lordship, he's now stuck in some other court. That's why your lordship.
This is the first matter I have
Yes.
fixed the matter.
That has been
from
specially fixed at 10:30 by your
Yes.
lordship.
10:30 it is fixed.
Yes.
As I am hearing this matter.
Your lordship, yes, your lordship kindly fixes it tomorrow, your lordship, at the same time.
I can make my submissions. Mr. Nag can come in the meanwhile. If he's stuck in some other court, he can come in the meanwhile.
He was just outside the court. I have seen him.
Lordship,
In any case, there is a no adverse order resolution taken today.
yes, your lordship.
So I'm sure Mr. Nag won't get stuck for too long,
Our case
wherever he
also
is.
it has concluded.
না, না, এবার ওনাদেরটা কালকে
No,
কথা
I know
বলবো।
there are some reasons to be not to pass any adverse
Yes.
order.
So,
Yes,
to pass
yes.
any order in absence of any of the.
Any of the
Yes,
parties.
yes, yes. That is there.
That is the issue. But this matter I am hearing.
I know,
since
your
yesterday.
lordship, it's fresh in your lordship's mind.
Yes.
Now we now.
Not only press, I have engaged entire day for
Correct.
that,
Entire
for
half
this
day
matter.
went in this matter.
All the matters are stuck
Let
for
him
this
come,
matter.
let
Your
him
lordship
start.
kindly keeps it tomorrow. Mr. Nag shall place some judgments and conclude his submissions, your lordship.
Yes, what can be done?
Let him start his argument. So far reply is concerned. Mr. Nag will come. He is seen other court. Not like that he has not come. He will place the judgment.
Mr. Nar will place the judgment, thereafter a reply would be.
Yes, your lordship,
Mr. Medora.
kindly keeps it at the same time tomorrow, your lordship.
This court talks today, 2 days for this matter.
We can come back at 2 p.m. also today, my lord,
We have no difficulty.
if Mr. Nag is available. If he's stuck in some court now, I presume that matter won't go on for the entire day.
No, 2 p.m. I have some other
I see,
determinations.
I see.
You know
I'm
the
just trying to help and finish this matter.
original side matters. You
I
know
see.
the-
Oh, yes, today's Thursday. That's right.
Yes.
I know your lordship's original side matters.
কি আসতে পারবে না? সারাদিন মামলা চলবে।
না, না, ওটাতে জন্য।
This is also fixed matter, 10:30 fixed.
I know.
করতে চায় না।
Apologize, your lordship, kindly keeps it tomorrow.
You take note, Mr. Medora, you can start.
Sorry, I beg your lordship.
You can start.
I can start. Yes, yes, yes.
You start, you take note. Let's see how can we proceed. Okay,
Your
My
lordship.
lord. My lord, so far as Mr. Nag's submissions are concerned, which he had made yesterday, he had placed, my lord, reliance on the contract between my client and his client.
your item is item number two.
Item number 2, my lord, Ashok Kumar.
Item number 2.
He had 3 or 4 small points, my lord. I'll deal with them one by one.
Yes.
As I had submitted yesterday, my lord, the issue is, my lord, not about the fact whether another distributor can be appointed in my territory or not. That I'm ad item. Somebody else can be appointed. The issue is also not about whether my customers have a right to shift from me to some other distributor. That is also not in dispute. I agree that yes, if a customer is dissatisfied with my service, he can very well move to another distributor who is servicing his particular territory. The issue is also not about whether new distributors can be put in my territory or not. The only issue out here is whether my customers, whom I have developed and nurtured over almost 3 decades or more than 3 decades, whether they can be arbitrarily, without any rationale, be taken away from me forcefully and given to some other distributor in order to help that distributor. So in other words, I am doing a good job. That is not right. Somebody else should also get your benefit. So you will be punished for doing well. That is the crux of this issue. And without any logic or without any rationale. This being state, my lord, Article 12, Article 14, 19, 21, 300A, all come into effect, my lord. And therefore, the test of reasonableness has to be satisfied, even though there is a contract between the parties. Now, one of the arguments raised yesterday by Mr. Nag was with regard to the terms and conditions of the contract between my client and his client. He had placed, my lord, particularly reliance on clause 11 of the contract between the two of us. Lordship will kindly take the contract, which is at page 33. I'll also show, my lord, in the passing, some of the other clauses of the contract, which will show that it is the oil company itself which wants me to increase my business, invest money, etc., etc. And after doing all this, they cannot unilaterally take away my clients. My lord, will kindly take page 33 is where the contract starts. Page 34, my lord, the last clause at the bottom, B sub-Roman 2. The corporation reserves the right, without any reference to or consent of the distributor, to appoint one or more additional distributors in the same territory referred to clause 1A above, and such additional distributor or distributors shall be entitled to make sales of Bharat Gas in the same territory without any objection from the distributor, and distributor shall not be entitled to claim any overriding remuneration, commission, or allowance for the purpose. So, my lord, this is the clause which gives the oil company, my lord, the right to appoint other distributors. Mr. Nag is here, so if he wants to show his one or two judgments, he can do that, and then I can.
I have certain documents to show, my lord. That's why
That he can file his affidavit in opposition, bring these documents on record, and thereafter show them.
That's why I submitted. So let me complete my submissions.
Yes,
first,
you can complete. Just you are not there.
No, I understand. When I was stuck in another.
Very good. You proceed.
When yesterday I submitted before losses that the challenge with regard to the earlier circular is now pending before the Honorable Supreme Court, and recently an order was passed admitting the civil the SLP and the civil appeal number has been granted. But in the meantime, before this new circular was introduced, a submission was made before the court, and with the leave of the court that was introduced. Maharaj, may I place that order? Mr. Tushar Mehta, the learned Solicitor General of India, appearing for the oil marketing company, submitted that perhaps this court need not have to adjudicate these petitions on the merits as they are coming out with a new policy. He submitted that some time may be granted to place the new policy on record. Post it after 4 weeks. Yes. So even the new policy that was introduced, before introducing the new policy, the submission was made before the Honorable Supreme Court, and it was also submitted that will be placed before the Honorable Supreme Court for consideration. Civil appeal যেটা admit হয়েছে। Civil appeal হলো যেটা। Civil appeal। This was the order by which the SLP was granted and the leave has been, SLP was allowed and the leave has been granted, and it has been converted to a civil appeal now. This order is of 8th April 2025. After that,
Civil appeal was granted. SLP was granted on September. No. When
SLP was filed long back. SLP was filed, my lord, in 2020.
No, what is the order?
The last,
The first order, Your Lordship, kindly see the order.
Which is the last order?
It was 30th September 2019. First order. Kindly see. First page, second line.
No, I
Arising
understand.
out of interim final judgment and order dated 30th September 2019.
What is the latest order? Among
Mana,
those?
the order that I have placed, the last order that I have placed is of 8th of April.
This is prior to coming into force the circular. This is 22nd of May.
8th April 2025.
And circular is dated for 22nd May. Thank you. 21st September. Yeah,
The learned Solicitor General of India has approached. This is the last order.
No, my lord. The last order is the
SLP,
SLP, 8th April.
8th April order. Okay.
8th April. There was another order, I will show that, but it was only adjourned. The 8th April order. 8th April. না না এটা 2018 এর সার্কুলার চ্যালেঞ্জ করে যেটা
This is also 30th September. Kindly see the date.
No, I have submitted that. This is the SLP which is pending before the Honorable Supreme Court in relation to the challenge of the earlier circular of 2018.
8th April order is the last order.
8th April order, my lord, in the 8th April order, the last page you is application for permission to file SLP is granted.
Granted.
Leave granted.
Yes. And submission of learned Solicitor General of India is of 28th of January 2025.
Yes.
Now this is the last order which in which it is only adjourned as prayed for the matter, lease the matter we commencing from 28th July 2025.
Does not appear which order was under challenge. কি number দিয়ে?
এই তো সিভিল অ্যাপিল নাম্বার পড়ে
Right.
হ্যাঁ।
Which order was under challenge in this matter?
বম্বে হাইকোর্ট
18.
হ্যাঁ আমি তো 18 এর কথাই বলছি
18 এর relation কি আছে? ঠিক আছে।
না
Yes.
These are all my lord Bombay High Court first order.
and then other high courts also there are some other high courts also, all those civil appeals were tagged together and been heard together.
Very
Now,
good.
now during pendency of appeal, before introducing the new policy, the submission was made that the earlier policy is no more there. The government is coming up with a new policy, and that may be placed before the Honorable Supreme Court, and that leave was granted. No.
Yes, Mr. Nag, proceed.
The issue that I raised, that the main issue, the consumers below either whether the consumer belong to the wild marketing company or the consumer belong to the distributor concern. My humble submission is the consumer belongs to the wild company and not the distributor. Distributor is merely a selling agent. Even the product also belongs to the wild marketing company and not to the distributor. Well, I've also submitted before your losses that the documents for enrollment of a particular consumer. Now from those documents also it will appear that the consumers belong to the wild marketing company and not the distributor. May I place this the enrollment form, which is the voucher, subscription voucher as well as there are two things, my lord. Yesterday I have shown that particular clause from the manual also, wherefrom it will appear that the choice is given to a particular consumer to enroll with any of the three oil marketing companies for receiving domestic LPG gas. Now it is the choice of the consumer also to enroll with any of the oil marketing companies according to his or her choice.
Yes.
Now, suppose today somebody enrolls with Indian Oil Corporation. Tomorrow, that particular consumer, according to the choice, can also enroll the transfer the enrollment with another oil company. So, when the first enrollment is made, subscription voucher is given, and when transfer has to be sought for, again a transfer voucher is given. So all these things, it's enrollment and thereafter transfers, from all these documents, it will appear that the consumer belongs to the oil marketing company. May I place that voucher form, my lord? Kindly see. Again, this is Bharat Petroleum Corporation Limited form. So oil marketing company's form. The enrollment form is of the oil marketing company. It's not of the distributor. The oil company will identify the distributor after a particular the area, the address is given by a consumer.
Yes.
In the application form, then the oil marketing company will identify one of its distributor to be tagged with that particular consumer to cater the LPG gas service to that particular consumer. And accordingly, in the form itself, when the enrollment will be given, in that the name of the distributor as well as its address will be indicated. In the document number, thereafter date, and thereafter consumer number. Now, after a consumer number is generated, then the oil marketing company will give the details of the distributor code, name and address in the next column. Now, kindly turns to the next page. Bharat Petroleum Corporation Limited.
Yes.
Liens to the consumer and the consumer taken on loan from lien to না lien হবে না দেখো তো একটু ভালো কপি আছে loans. From the company, cylinders and pressure regulators, collectively equipment, required supply of the company's product, that is Bharat Gas. The consumer shall deposit with the company an amount in accordance with the company's tariff in force from time to time as security for the due fulfillment by the consumer of his obligation hereunder. The company shall be under the obligation with regard to the manner of use of or disposal of the funds received as deposit from the consumer, nor shall it pay to the consumer any interest thereon. The consumer shall remain responsible to the company for safe custody of the equipment, and he shall not sell, mortgage, or otherwise dispose of the equipment or create any interest therein or charge thereon in favor of any party. The consumer shall not remove the equipment to any address other than that shown on shown on the obverse hereof without obtaining the prior written permission of the company's distributor concerned. Further, in the event of the consumer's departure from the area serviced by the distributor, he shall return the equipment to the distributor.
Mr. Nag, why you want to show these provisions?
The purpose of showing this document is to show that the consumer is enrolled with the well company,
Yes.
belongs to the well company, and all the responsibility, the obligation of the subscription, so far as the consumer is concerned, it is towards the well company. It's not the distributor. Now kindly see the point number 12. The company as well as the consumer shall be at liberty to terminate this contract. So the contract, the enrollment, the subscription, the relation between the a particular consumer and the well company. The contract is between the consumer and the well company. It is with the well company. Kindly see the point number 12. It will be clear from that. The company as well as the consumer shall be at liberty to terminate this contract at any time by giving 15 days notice in writing. So if the contract is between the consumer and the particular wire marketing company, then it is very much apparent and evident that the consumer, the relation of the consumer with, so far as the service is concerned, is with the oil company. The contract is also with the oil company. Even if there is a termination of the contract also, that will be at the either at the instance of the consumer or at the instance of the oil marketing company.
Yes.
Now, before just below that, kindly see, I submitted that this particular form, enrollment form, is applicable for two purposes. For at the very inception, when the relation starts between the particular consumer and the particular oil marketing company, and as well as when the relation ceases. There is a subscription voucher and there is a termination voucher. Even kindly see the last two columns at the bottom. The first one is for subscription voucher only, the first part.
Yes.
And the next one is for termination voucher only.
Yes, Mr. Nag.
Now, if losses kindly sees the writ petition, what is the case made out in the writ petition? Para 4. At page 3, it starts from page 3. The
Yes.
present writ petition has been filed challenging inter alia the validity and legality of the aforesaid circular dated 21st February 2025 issued by the respondent number 2, by virtue of which it seeks to restructure the LPG market. Kindly see what is the purpose according to own admission of the writ petitioner. Restructure the LPG market by transferring customers of the existing distributorships, such as the petitioner, in an arbitrary, irrational, and discriminatory manner. It is stated that the respondents have arbitrarily propounded a formula whereby the customers of the existing distributors which have refilled the sales more than or in excess of 100% of the ceiling limit will stand transferred to new distributors to achieve a purported market viability of 50% of the ceiling limit for new distributors. So, according to the own admission of the petitioner's case only, this policy has been made to balance the market.
Yes.
So that a particular distributor may not have to cater to more consumers, because it's all about service, and the service provider is the well marketing company. The product belongs to the well marketing company. The service provider is the well marketing company. Now, the service provider shall be entitled to frame any policy which, according to their own wisdom and expertise, will be more effective so far as the service to its consumers are concerned. Because it is for the larger public interest.
Okay.
Now, what is the case that has been made out? What is the grievance of the petitioner? How the petitioner will be prejudiced so far as introduction of this particular circular is concerned? The only case made out is loss of business. It's not that the distributorship is not going. It is not the case that the petitioner will be out of business, because it is a case of termination of the distributorship. Even your losses has considered so many cases where the termination of the distributorship, which tantamounts to loss of business, violation of Article 19(1)(g). Even in those cases also, the writ jurisdiction, interference of the constitutional code under Article 226 is very restricted.
Yes.
Even in those cases also, where there is a particular person is losing his particular business altogether. Here the case is there will be only a loss of profit.
Yes.
It is not a case where the distributorship is going because of the policy. Only there will be a loss of profit in any case. Now the issue is, if that is the only case, whether that tantamounts to violation of Article 19(1)(g). Even if you losses kindly consider, once the 19(1)(g)
Yes.
on Article 19(1)(g), may I please?
Yes.
All citizens shall have the right. Now G. Right to free. A is freedom of speech and expression. B is to assemble peacefully and without arms. C is to form association or unions.
G. To
G,
practice
to
any profession.
practice any profession or to carry on any occupation, trade or business. It is not the case of the petitioner. That's because of this particular circulation, the circular, this policy, because of this particular policy, the petitioner is losing his right to practice any profession or carry out any occupation, trade or business. It is not the case. It could have been a case in a situation where the distributor is terminated. Now, kindly see what is the, there is one exception so far as this particular article 19(1) in G is concerned. It is exception is given in 19(6)(I). The professional or technical qualification necessary for practicing any profession or carrying on any occupation, trade or business. The government will, like what C says, government will, it is open for the government to frame certain policy to give certain to frame policy as to which citizen can practice which kind of profession, and for that particular purpose what should be the criteria, the qualifications. Somebody can't practice medicine without having a MBBS. So that is what 19(6)(1) says. I says. So that is the exception. This is the only exception to 19(1)(G). Now, the case of the implication of the circular is transfer of certain existing consumers to another distributor.
Yes.
From the petitioner. My humble submission, my lord, that is not a violation of Article 19(1)(G).
Yes.
And this policy is not only an instruction. This policy is not a mere instruction of a particular oil marketing company. This is a policy of the government altogether. Ministry of Petroleum and Natural Gas has approved this. So it's a policy of the government. Now, your lordship knows there are a lot of judgments which says the scope of judicial review so far as policy of the government is concerned. May I place some of the questions? So the first, may I place a judgment of a coordinate bench of this honorable court. Done. Internal page 3 of the judgment. In that case, there was a policy for distribution of ferry services through auction. That was under challenge, my lord. Internal page 3, second paragraph, my lord.
Yes.
Under such circumstances, the writ petition is disposed of. The court is of the view, when the punchant authorities themselves have decided that the ferryguard should be settled by public auction, such a policy decision cannot be interfered with under Article 226 of the Constitution.
Yes.
The fourth paragraph, the court does not have any authority either to set aside the auction or to hold the policy of the authority to be bad in law for the following reasons. Judicial review of an administrative decision is permitted only when the decision-making authority does not act in accordance with law or acts arbitrarily and with malafide intention. Now, here, my lord, there has been no case made out, because according to the petitioner's own admission also, the policy has been framed to balance the market. So there is no case made out, only mere pleading that it's arbitrary. It can't be treated as arbitrary. A specific case has to be made out why it is arbitrary. There is no case made out of malafide intention. Now, the Honorable Court has also relied upon the judgment of the Tata Cellular, where it's in Tata Cellular. I also got the judgment. It's para 74, where this principle has been laid down, my lord. Hmm, 94. The same, it has been quoted here. I will also give the Tata Cellular. Yeah, no, yeah. Para 94. The modern trend points to judicial restraint in administrative action. The court does not sit as a court of appeal, but merely reviews the manner in which the decision was made. The court does not have the expertise to correct the administrative decision. If a review of administrative decision is permitted, it will be substituting its own decision without the necessary expertise, which itself be fallible. Now, the other points are all related to the tenders. This, so far as the policy is concerned, this 1, 2, 3, these are the three principles have been laid down.
Yes.
Now, next. It's 2002 2 SCC 333. Paragraph 45 and 46. May I place my lord? It has been, the para 45 refers to an earlier judgment of in the case of Narmada Bachao Andolan versus Union of India. It is now well settled that the courts in the exercise of their jurisdiction will not transgress into the field of policy decision. Whether to have an infrastructural project or not, and what is the type of the project to be undertaken and how it has to be executed, are part of policy making process, and the courts are ill-equipped to adjudicate on a policy decision so undertaken. The court, no doubt, has a duty to see that in the undertaking of a decision, no law is violated and people's fundamental rights are not transgressed upon, except to the extent permissible under the Constitution. Para 46. It is evident from the above that it is neither within the domain of the courts nor the scope of the judicial review to embark upon an inquiry as to whether a particular public policy is wise or whether better public policy can be evolved. Nor are courts inclined to strike down a policy at the behest of a petitioner merely because it has been urged that a different policy would have been fairer or wiser or more scientific or more logical. It's 2007 4 SCC 737,
Yes.
paragraph 16. May I please, my lord? The scope of judicial review of governmental policy is now well defined. Courts do not and cannot act as appellate authorities examining the correctness, suitability, and appropriateness of a policy, nor are courts advisors to the executive on matters of policy which the executive is entitled to formulate. The scope of judicial review when examining policy of the government is to check whether it violates the fundamental rights of the citizens or is opposed to the provisions of the Constitution or opposed to any statutory provision or manifestly arbitrary.
Yes.
Courts cannot interfere with policy on the ground that it is erroneous or on the ground that a better, fairer, or wiser alternative is available. Legality of the policy and not this wisdom or soundness of the policy is the subject of judicial review. Here, my lord, the case that has been made out is that it's not that the petitioner is losing his profession or to right to carry out his business. So it can't be said that it's a violation of the fundamental rights. No case has been made out that the policy is contrary to any law in force. Now the issue that where from the petitioner is getting the right to approach this honorable contract.
Yes.
It's not a public interest litigation. The right that the petitioner is getting to approach this honorable court is the contract. That is the basis. I have shown you losses the relevant clauses of the contracts to which both the wile company as well as the petitioner are bound. Now, if it can only be a case to challenge the policy so far as the petitioner is concerned arising out of the contract, that particular, if that contract is not in place, the petitioner could not have any right whatsoever, could not have any grievance also so far as the policy, impugn policy is concerned.
Yes.
Only because of the contract, the petitioner is coming up with a grievance. Now, if it is that all the rights, even to approach this honorable court, the petitioner is enforcing his right from that particular contract. That means petitioner is taking the advantage of the contract. That is the right, that is the only right wherefrom the petitioner is approaching this honorable court. The petitioner is therefore enforcing the contract. Filing this writ petition is enforcement by virtue of enforcement of that particular contract. No other right.
Yes.
So if the petitioner is seeking enforcement of the contract, then he can't choose a particular clause of the contract and deviate from other clause of the contract. Petitioner has to enforce the contract in its entirety. He can't rely on a particular clause to approach this honorable court and avoid to perform other clauses of the contract. Now kindly see para 19. May I please? So in effect, this is a contractual dispute arising after the distributorship agreement. So a contractual dispute. May I please para 19 once more?
Yes.
There can be no dispute to the settled legal proposition that matters disputes relating to contract there can be no dispute to the settled legal proposition that matters disputes relating to contract cannot be agitated, not terms of the contract can be enforced through writ jurisdiction under Article 226 of the Constitution. Thus, the writ court cannot be a forum to seek any relief based on the terms and conditions incorporated in the agreement by the parties. Now kindly see what was the issues here. I pointed out before is that if the contract is to be, even if the writ petition is filed for enforcement of a contract, then the contract has to be enforced in its entirety, not in isolation. Now kindly see the proposition, the principle of appropriate and reprobate. Para 15 of this judgment.
Para 15.
Para 15. A party cannot be permitted to blow hot, blow cold, fast and loose, or approbate and reprobate. Where one knowingly accepts the benefits of a contract or conveyance or of an order, he is stopped from denying the validity of or the binding effect of such contract or conveyance or order upon himself. This rule is applied to ensure equity. However, it must not be applied in such a manner so as to violate the principles of what is right and of good conscience. Para 16. Thus, it is evident from the doctrine of election is based on the rule of estoppel. The principle that one cannot approbate and reprobate is inherent in it. The doctrine of estoppel by election is one among the species of estoppels in pays, which is a rule of equity. By this law, a person may be precluded by way of his action or conduct or silence when it is his duty to speak from asserting a right which he could have otherwise had. Now kindly consider, I have relied on clause 11 of the contract, fully knowing, well aware of the consequences, as well as the legality of validity of all the guidelines, manuals in force, which will be binding on the distributor. The distributor has entered into the contract agreement. Now the distributor cannot say that I won't abide the manual or any guideline or any instructions or any orders. I have specifically relied on the manual which specifically deals with this particular scenario of transfer, surrender.
Yes.
Now, a particular clause was, I also referred on the particular clause of choice of the oil company for appointment of more than any number of distributor on a particular area. Now, this issue, the clause of this particular, this particular clause of the standard contract were earlier also referred while the earlier circulars was challenged. Now, your losses may kindly consider reliance is different and interpretation is different. How it has been relied, that is an important issue to be considered by your losses. How that particular clause was relied, what was the argument made referring to that particular clause. Now, today what I am submitting before your losses is that why that clause is important. Because if the oil company is given a choice to appoint as many as distributor, the oil company may decide to cater its consumers on a particular area, then today, if can we appreciate the scenario, today a particular distributor is having 100 number of consumers. There will be people going in, going out from particular area. Now tomorrow there is another distributor been appointed. New consumers or even the existing consumers of the oil company may opt for another distributor. So in that case, this same principle has to be considered, madam. If there is a choice of, if there is a provision for appointment of as many as distributor in a particular location is concerned, even in that case, the same argument will be made. Loss of profit. A new distributor has come up, so I will lose my profit. Those particular consumers would have been enrolled with me without going, in case there is no other option. The same principle. That is the only case that has been made, loss of profit. So even in such scenario also, the same effect will happen. The scenario is the same. It will be loss of profit of an existing distributor if there is an appointment of another distributor in the same area. Now, so far as this particular for appointment of, so why the there cannot be any restriction on the oil company to appoint as many as distributor the oil company decides in a particular area. Why this right is given? Because that right is there in the constitution itself. Because I told you, losses, this the competition, there cannot be a restriction in trade. A competitor in trade cannot plead that it's a violation of Article 19(1)(g). Only because a particular trader is losing his business, losing his profit, that cannot be a violation of 19(1)(g). And that is, and this law has been settled long back. May I place that one? 19(1)(g). The only restriction to 19(1)(g) is 19(1)(6), because this is the principle that there cannot be a restriction in the trade. A competitor in trade cannot take the plea of violation of Article 19(1)(g).
Yes.
Well, 1971 SCC 575, para 8. The last 3 lines of para 8, the right to
Yes.
The right to carry on business being a fundamental right under Article 19(1)(g) of the Constitution. Its exercise is subject only to the restrictions imposed by law in its interest of the general public under Article 19(6)(i). So loss of profit can't be treated as a violation of 19(1)(g). And this particular judgment was delivered in a situation where this competition in trade was the issue. That was the only case made out. While dealing that issue, the Honorable Supreme Court has held that no. The only restriction is 19(6)(i).
Yes.
Now, so far as the only case that has been made out, that is loss of profit. Now, kindly cease the writ petition, my lord. There is only, Elosis knows that only mere pleading is not sufficient. There has to be details. There has to be particulars. What has been the case made out? The argument was made that consumers are of the distributor. Distributor has made huge investment, has given lot of time, lot of effort to build up the consumer. That was the argument, my lord. Now, kindly see, if that be the argument, there has to be particulars given in disclosed in the petition. The equipments belongs to the well marketing companies, all the equipments to cater service.
Yes.
Now, also, so far as these equipments are concerned, who is investing? Consumer. That I have shown in that subscription voucher. It is the consumer who has been investing,
No, no,
not the distributor.
no. Consumer is, you are showing that the subscription voucher, that is the equipments that is
Yes, I'm saying that.
attached with the cylinder. That
Right,
equipment they are
right. So that,
But they are arguing on that point that they have made huge structure, huge infrastructure
right, my lord,
to cater the
right,
large
right,
number.
right,
This is the argument.
right.
Large
So,
number of consumers,
right.
and if they lose the consumers, their entire money would go. This is the real submission.
Right. Now kindly consider at what point of time this investment means that. So the investment that has been made is at the time of grant of distributorship. Investment, if that be so, then the investment made is at the time of grant of distributorship.
No, this is not also the argument. The argument is that at the time of granting a distributorship, they have the infrastructure, but through the contract, you have imposed restriction to a large number of customers may be attached with you. They have extend their consumer base on your contract. That's why if you lose the customers, they will lose the business. This is the only submission.
Now kindly consider all these terms and conditions are there in the selection guidelines, the unified selection guidelines. So all these conditions are well within the knowledge of a particular distributor who has participated in the selection process.
Yes.
These terms and conditions are there in the guideline. these are the terms of the selection event. So in the unified selection guidelines, which is the brochure where all the terms and conditions of a proposed distributorship had been laid down. So those were there even before the appointment, because based on those terms and conditions, the selection was made. So these terms and conditions were well within the knowledge of a person opting for a distributorship. So the losses have also seen that the policy, the first part of the policy, that's why also deals with the unified selection guideline. Kindly see the policy once, my lord. Page 47.
You are referring manual?
No, the policy under challenge, the improvement policy.
Okay, okay. Page 47.
Yes, the first chart from the top, the second paragraph. Further, MOP has approved the following changes in clause number 2.4.1.1.I under the notes of unified selection guidelines. So the unified selection guidelines, and can also place even in the unified selection guidelines, all the terms and conditions are given. And any person who is opting for a distributorship are well aware of the consequences or of the terms and conditions of the distributorship. And the investments were made at the threshold there are two requirements. One is you have to provide a go down for storage of the cylinder license. So that is an investment. Then which area you have to cater, how many there is a marketing viability also disclosed, how many consumers you may have to serve. So all these things were disclosed even at the time of selection. Accordingly, the investments were made. The two major investments are being made. One is the construction of the godown. The other one, because there are two things which are required for LPG distributors, is online retail outlet. Two premises are required. One is for storage, godown, cylinder, and one is the shop room, the sales office.
Yes.
So these are the two premises which were required. Now the investments for construction, for making the land available and everything, for construction of the godown, these are done at the threshold, at the very beginning. Now how the policy, if there is a if there is a loss of profit, if there is a loss of investment, this has to be specifically disclosed. Even if losses for it is a well settled law now, even for liquidated damages which is quantified in a contract, a liquidated damages, quantified liquidated damages in a contract, a party can't seek for that particular liquidated damages without proving that event.
Yes.
Apart from liquidated damages, it's different. That you have to also prove. The damages actually suffered, that you have to prove. Then you have to disclose, you have to prove. And even for liquidated damages also, the same principle will apply. So if a case has been made out that there is a loss of investment, there has to be detailed particulars disclosed in the pleadings, in the documents. Mere statement will not be sufficient, my lord.
Okay. Yes, anything, Mr. Nag?
Alone, give me 5 minutes. Another 5 minutes. Now, so far as the earlier circular is concerned, petitioner has not challenged the 2018 circular.
Yes, you have said.
I have said so, man. The transfer which took place by virtue of 2018 circular, even those were also not challenged when that particular circular was in force, was also not challenged. Now here
In the prayer, they have just incorporated. this.
incorporated that too in the nature of an
Declaration.
interim relief.
They have to
No
declare.
no read. Kindly consider there is
No mandamus.
no mandamus so far as transfer and all are concerned. Now, even if I go by the pleadings, my lord, leaving the prayer apart, para Q at page 13,
Yes.
the petitioner has referred to a representation, which has also been annexed, my lord. I think it has been annexed 28th June. Now, kindly consider two. First, consider page 85 once. Now, this is a representation made in 2023, July 2023, referring to the earlier circular. At page 87, they have the petitioner has made out have tried to made out a case of why of disagreement of 2018 circular. The lack of consultation, the first ground that was taken, that policy, the decision was taken, the policy was framed without consulting. Now, second, long-term investment. Kindly appreciate. Investment means the long-term investment. The implementation of the said circular will have a cascading effect in as much as it will render the added infrastructure, manpower, etc., which was at the behest of BPCL from time to time completely futile. It will result in trickle-down effect in as much as existing distributors like us. Then next is lack of rational.
No, it is in respect of 18.
18. So even when what why I am placing this, my lord, only representation. There is no the court petitioner has not had not approached the honorable court. Even for consideration of that particular representation. Now, so far as the new circular is concerned, there is another representation which is at page 93.
Yes.
Now, kindly sees admits that curtailment made pursuant to the earlier circular in 2019. Kindly sees para 2. On 11 September 2019, we were in receipt of an email communication from your office stating that 5675 customers had been transferred from our distributorship to another LPG distributor. So this was never challenged. At that point of time also the case of investment was there. Now the citations of all the judgments passed by different high courts. And what was the prayer made? Para 15, page 96. We therefore request your office to formally record our objection and to refrain from initiating or facilitating any customer transfer or related restructuring action under the circular dated such and such until the legal validity of the policy is finally adjudicated.
Yes.
Now kindly see see para R, the pleadings once more again at page 13. I read para Q where the reference of the representation was made, and then R.
Yes.
Thereafter, some of your petitioner's regular customers approached your petitioner and inquired about whether your petitioner had wound up his business in as much as different supplier was now supplying cylinders to them without them making any request for such change and without taking their consent. Consequently, your petitioner immediately check the online portal of the petition number 2 pertaining to your petitioner and was shocked to surprise to discover that 1918 customers of your petitioner had been unilaterally transferred by the petition respondent number 2 to another distributor on June 20, 2025 without the knowledge and or consent of your petitioner and without any intimation. Your petitioner is now apprehensive. Such apprehension being bona fide and reasonable in prevailing facts and circumstances that the respondent number will take further steps to transfer and or remove further customers to your concern. So that is the challenge. Further.
Yes.
On an apprehension. And para 11 also, my lord, can you see 19(1)(g) 14. So today, my lord, in this particular writ petition, only the policy is under challenge. Neither clause 11 of the contract is in challenge, nor the manual is in challenge, nor any instructions or order of the corporation is in challenge. So far as the distributorship of the petitioner is concerned.
Yes.
The policy is still in the policy so far as West Bengal is concerned. This policy is still in force. The policy so far as the other states also, the policy has not yet been struck down by any of the high courts. Some of the high courts have stayed the operation. Even in those cases also, losses may appreciate how the courts were apprised to defend the policy. All those orders which were placed before your losses, 1 or 2 pages order, even in one of the high court, I find there was no representation also so far as the While Company or the Union of India was concerned. Only on the very same day, after hearing the petitioner, a stay of operation for a particular period of the policy was granted. So adequate opportunity, I won't say adequate opportunity was not given, but in my humble submission, there was no proper representation also to defend the policy on the part of the concerned oil marketing company as well as the Union of India.
Yes.
And also consider that it's a case of the grievances transfer. So the transfer of a consumer, which is ultimately belong to the oil company, transfer of such consumer from one distributor to another distributor cannot amount to violation of Article 19(1)(g).
Yes.
So in my humble submission, my lord, so far as the merit, legality and validity of the policy is concerned, I may be permitted to file my affidavit
Yes.
to place on record to supplement the legality and validity of the policy, as well as to disclose all relevant documents so far as the manuals as well as the vouchers that I have placed before lordship. And at this stage, in my humble submission, my lord, there is no scope for any interim order in this particular writ petition, because admittedly no mandamus has been sought for in relation to the transfer. And so far as the policy is concerned, my lord, kindly permit me to file my affidavits to defend the policy. And even if your losses considers the prayer for any interim order, your losses may also clarify. The interim order may be in respect of the policy, but your losses may also clarify that the oil company has a right to exercise whatever rights it has to exercise under the contract as well as the manual, which are in force. And these are my humble submissions.
Okay.
After my learned submission, I shall be try to get after my submission, I gave the opportunity to qualify them.
May please, your lordship, my lord. My lord, I had already started making submissions before Mr. Nag came in.
Yes.
My lord, may I continue from the submissions which I was making? Therefore, my lord, I was placing, my lord, certain clauses of the agreement, some of them which had not been placed by Mr. Nag and some which had been placed by him. Kindly, my lord, come to page 33 of my writ petition. Which is the
Yes.
agreement between the petitioner, my lord, and my lord, the oil company, Mr. Nag's client, my lord. The first clause which I placed before your lordship for your lordship's consideration was the clause, the last clause appearing at page 34 of my writ petition, my lord, which basically gives BPCL the right to appoint other distributors, but not to take away my customers. So that right they have. They can appoint other distributors. We are ad idem on that. My lord, we kindly turn over the page to page 35 and see small Roman 3 right at the top, my lord, which talks about, my lord, how I have to achieve minimum sales targets. Without prejudice to the above, the corporation shall also be entitled to require the distributor to effect minimum sales of Bharat Gas. My lord, I pause here for a moment. So, my lord, in other words, my lord, there are certain targets which the petitioner has tried to achieve. So, this whole story which has been concocted by BPCL, that look, all the customers come to me, then I distribute them to different people, etc., my lord, that is nothing, my lord, but absolutely incorrect. The customers are entirely developed by me. All the customers come to me, and then they are incorporated into the system. Mr. Nag, my lord, during the course of his submissions, placed a lot of reliance on this form which he has handed over to your lordship today, this enrollment form or whatever the terminology might be. These forms, my lord, are available, my lord, with the distributors. I go and get the clients, or the customers come and approach me. These forms are lying with me. They fill up these forms in my presence in my office. So it is not that these customers or clients are going to BPCL's office, filling up the forms, and thereafter BPCL is deciding which customer or client will go to which distributor. That is not the case, although that is the impression which has been attempted to be given to this honorable court. So this form, my lord, comes to no aid or no assistance to Mr. Nag's submission. These are forms which are available with all distributors, and they are filled up in my office or in the respective distributors' offices. So point is, my lord, the customers or the clients are my customers and clients, and that has been dealt with also by your lordship's judgment, as also in the Bombay High Court judgment, which I will indicate in a short bit of time. So that is with regard to this form. Coming back, my lord, to the agreement, my lord. Kindly see para sub-Roman 5, my lord, at page 35, my lord. The distributor shall make his best efforts for enrolling customers and canvassing business, and for developing and increasing the sale of LPG within the area allotted to him. So again, my lord, an obligation has been cast upon me to increase the business, to increase the number of customers, to increase the number of clients. And it is my obligation. It is not, it runs contrary to Mr. Nag's submission that the clients are his, that he is developing the business, and then out of his generosity, he's giving different clients to different distributors. So that again runs contrary to the case attempted to be made out. So, my lord, if I have to develop my business, if I have to increase customers, naturally, my lord, that will call for significant increase of investment on my part. Because if I need more customers or more clients, as is mandated by BPCL in the agreement, then I will need more more my lord, personnel to distribute, more manpower, more storage space, more vehicles to distribute all these gas cylinders to different customers. So therefore, my lord, there has been significant investment made by me over the last 35 years since I've been acting as a distributor. And today, if some of these customers and clients are taken away forcefully, unilaterally, arbitrarily by BPCL, that is the loss which I will suffer. And my lord, a lot has been said by Mr. Nag that you will only suffer some business loss. Your business is not being taken away. You still continue to be a distributor. But that, my lord, there is a fallacy in that argument. Today, I agree that yes, I continue as a distributor, but this significant business loss which I will suffer ultimately will affect the viability of my business. Today, my lord, let us take an example. Today, if I have a customer base of 1,000 customers, I have developed infrastructure to cater to these 1,000 customers. I have taken loans for vehicles, I have taken loans, taken spaces on rent to store these cylinders. I have employed personnel to act as manpower to cater to the customers, to distribute, to go and deliver these gas cylinders, etc. So today, forcefully, 200 out of these 1,000 customers are taken away. Then, my lord, a lot of my investment will significantly go down the drain, because then I do not need the infrastructure which I have built. I have taken loans. I still have to service these loans, but these vehicles are lying idle. These manpower whom I have engaged today to cater to these 1,000 customers, I do not need all of them to cater to the 800 customers. So therefore, my lord, the manpower will be lying idle, but costs will be continuously incurred by me. So ultimately, it will lead to a situation where I will be compelled to shut down my business. And that is why, my lord, Article 19 comes to my aid and rescue. Mr. Nag is right that yes, it is a loss of business, not a shutdown of my business. But ultimately, this loss of business will lead to a shutdown of my business. And this business I have developed in terms of and as per the requirements of BPCL. They have only, my lord, dangled the carrot in front of me saying, increase your business, increase your customers, you will get more money, you will get more commission. They also benefit, I also benefit. So I have developed all these customers and clients at their behest and in accordance with the terms and conditions of the contract. There is no approbating and reprobating being done by me. I am also relying on the same terms and conditions of this agreement. So that is, my lord, this answer. My lord will also thereafter kindly turn over the page to page 36, clause 7 of this agreement. The distributor shall provide adequate facilities duly licensed by government or any other statutory authority for receiving and storing liquid petroleum gas cylinders. All such storage space must also be approved by the Chief Controller of Explosives for India or the Directorate for Explosives or his local representative. Such storage facilities shall be exclusively used by the distributor for storing LPG cylinders and for no other purpose. The construction, maintenance, and upkeep of storage facilities as per the conditions of permit or license would be the sole and exclusive responsibility of the distributor, who will also be liable to pay and discharge the entire expenditure for the same. So this is, my lord, another investment which is being required to be borne solely and exclusive by me. There is no cooperation or no lending hand given by BPCL so far as these obligations are concerned. Similarly, my lord, clause 8, which limits me, which says that yes, you will carry on business, but you will only carry on my business. You will only sell my cylinders, nobody else's cylinders. So it's like an exclusive arrangement. The distributor will not, during the currency of this agreement, distribute or sell or be in any way concerned in distributing similar products of any other company or product without the previous consent in writing of the corporation. Infringement of this clause will entitle the corporation to terminate the agreement as well as claim any compensation for loss of sales of which the corporation shall be the sole judge. So, well, I am bound only to sell his products. If I'm bound only to sell his products, how can he wake up one fine day and say, very well, I'm taking away these clients of yours and giving them to somebody else in order to make somebody else's business viable? That, my lord, is grossly unfair, unreasonable, and therefore, my lord, arbitrary and violative of Article 14. That is the case made out by me in my writ petition. Now, my lord, we'll kindly turn over the page, my lord. Before, my lord, I come to clause 11, relied by Mr. Nag, my lord, just another two clauses which I will show, my lord, so far as the investment and the charges which I have to bear are concerned. Clause 12. Distributor shall, unless otherwise agreed to in writing by the corporation, bear all expenses incurred in connection with or incidental to storage, licensing, handling, loading, unloading, cartage from the distributor's approved godowns, delivery and sale and distribution of LPG cylinders, filled or empty, or any other equipment that the corporation may make available to the distributor, and the corporation will not be liable to bear such expenditure under any circumstances whatsoever. So again, my lord, these are more charges which are being incurred by me on a regular basis, and naturally, in view of, my lord, the increase of my number of customers, my costs have also gone up significantly. My investment has gone up significantly. Clause 14, my lord, also I'll just quickly indicate, also again relates to my investment at the behest of BPCL. The distributor shall at his own cost, in his own name, on his own account, procure and maintain such accommodation and facilities as are required for his business and as may be directed or approved by the corporation from time to time, including without prejudice to the generality of the foregoing, adequate storage accommodation for cylinders, both full and empty, pressure regulators and other articles supplied by the corporation, and B, such vehicles as delivery vans, three-wheeler scooters, etc., in such numbers and in such manner as may be directed by the corporation for transporting the full and empty gas cylinders and connected equipment. Now, my lord, will kindly come and see clause 18. Well, before I come to clause 18, my lord, another argument which has been sought to be made by Mr. Nag is that the customers are his customers. Now, my lord, it's very easy to say that the customers are his customers when it is convenient to him. But when it is inconvenient to him, if any loss or hardship is caused to any of these customers or clients, then he quietly absolves himself and says, no, I will not be liable for any harm which the customer may incur. It is you, the distributor, who will be liable. So when it is convenient, he keeps the customers as close to his chest, in fact, maybe inside his chest if possible. But when it is servicing the customers is concerned, any loss suffered by the customers are concerned, then he wants an indemnity from me. Then he says only the distributor will be liable. And the Bombay High Court has held on these terms that no, in view of such behavior on the part of the oil companies, the customers cannot be said to be that of the oil companies. Kindly see clause 18. The following provisions relating to indemnity by the distributor in respect of all claims, including third-party claims, shall apply to this agreement during the duration of this agreement and even after the termination thereof, in respect of any transaction arising in respect of the dealings between the parties hereto under this agreement. For the purpose of this clause, the expression distributor shall include a sub-distributor, agent, servant, licensee, employee, or other person nominated or appointed by the distributor or otherwise having any direct or indirect interest in this agreement, or storing, licensing, handling, loading, unloading, delivering, selling, marketing, distributing, or transporting LPG cylinders, whether filled or empty, and equipment relating thereto. The distributor, clause A, the distributor shall at all times fully and effectively indemnify and keep indemnified the corporation, its estates and effects from and against all losses, damages, claims, suits, legal proceedings, and otherwise, howsoever arising from or in connection with any loss or injury to person, the customers, or property in connection with any of the matters covered by the agreement or arising in the course of any of the contingencies referred to above or otherwise howsoever. Clause B, my lord, without affecting the generality of the indemnity referred to herein above, the distributor shall fully and effectively indemnify and keep indemnified the corporation, its successors, assigns, estate and effects, officers, employees and agents from and against all losses, damages, claims, liabilities, suits, legal proceedings, or otherwise howsoever arising out of any claims made by all third parties, whether on account of injury to person or loss of life or injury, loss or damage to any property, and occasion directly or indirectly, and irrespective of the cause of quantification of such loss or damage, and in particular and in respect to third-party claims covering all types of risks, and whether on account of any neglect, breach, or default in the observance and performance of the rules and the regulations from time to time framed by the corporation and or any statutory authority, and prevailing in respect of the storage, handling, loading, unloading, licensing, sale, distribution, marketing, transport, connection, or disconnection at customers' sites. So he absolves himself of any responsibility towards the customer. So when it is convenient, Mr. Distributor, these are your customers. You look after them. If they want anything, if they have any grievance, it is your headache. I will not be liable. So this is the conduct of the oil company. On the one hand, when it is convenient, they become his customers. On the other hand, when it is inconvenient to him, they become my responsibility and my headache. It's, my lord, a very unfair stance being taken by the state authority under Article 12. My lord, it goes on and on, my lord, but I will not trouble your lordship, my lord. Kindly also see one last thing at page 40. No warranty by the corporation. Right at the top. Again, my lord, the oil company is washing its hands. It is specifically agreed and declared between the corporation and the distributor that the corporation has not given, nor shall be deemed to have given, or agreed to any express or implied warranty as regards the manufacture or use of the LPG cylinders. So what he's supplying to me, he's not going to give me any warranty for that also, or for the customers. So complete washing. Kindly see B also. The corporation shall under no circumstances be liable or responsible for any loss, injury, or damage to the distributor or to the customers, their servants, employees, and agents, or any other person whosoever arising on account of any transaction under this agreement or as a result of the LPG cylinders of the said equipment being in any way defective or in unfit condition. So even if there is a defect, that also will come upon me, though I have no role whatsoever to play in respect of the manufacturing is concerned. Now, my lord, will kindly come to clause 11, which was relied upon to a large extent by Mr. Nag at page 37. The distributor shall faithfully and diligently observe and carry out all directions, orders, terms, and conditions as may be issued by the corporation from time to time and as may be contained in the corporation's LP gas manual, and any amendments or modification as may be made by the corporation thereto from time to time. The distributor hereby confirms that he has received a copy of the LP gas manual and the general directions as circulated by the corporation on the date of this agreement and agrees to abide by and perform the same. So, my lord, Mr. Nag's contention is that whatever is written in this gas manual, that will also apply to you. And according to him, the gas manual entitles or empowers the oil company to transfer the customers, the existing customers of any distributor unilaterally without giving any reason whatsoever. Kindly, my lord, take a look at the gas manual now. My lord, will first away, my lord, come to page 5 of this manual. Some background is required, my lord, before I go to the clause which Mr. Nag had relied upon. Page 5, my lord, the top is, my lord, introduction. The very first word at the top of the page.
Yes.
Lordship has, my lord. Just the first paragraph I would like to place reliance on, my lord. This section contains directions on the technical aspects relating to LPG cylinder installations. The main objective of these directions is to promote safety and customer satisfaction. Care has been taken throughout this section to indicate by the use of the word must those requirements to follow which are obligatory, and by the use of the words recommended or should the other requirements meeting which are not absolutely essential but are nonetheless desirable. So, my lord, the distinction is sought to be made, my lord, between what is mandatory and what is directory. So, the language of the manual has to be appreciated by this court. Now, kindly come to, my lord, page 61, which Mr. Nag had relied on yesterday. Page 61, my lord, the third of towards the top, my lord, of 25% down, my lord. Surrender of area or customers and ceiling limits. The distributor should, well, I will kindly make note of this word should. So it is not mandatory. It's a mere directory or desirable. The distributor should what? Should surrender when asked for by the corporation such of those areas or customers as demanded by the corporation. And when can the corporation demand this? My lord, kindly see the next sentence which qualifies the previous part of this sentence. On consideration of viability, refill, sale, ceiling limits for effecting better customer service, etc. So, my lord, if at all, in terms of this manual, if at all it can be argued that the oil company has a right to transfer, that transfer can only be done after an exhaustive study is done and after considering the viability or the refill, sale, ceiling limits for effecting better customer service. That is not the case, my lord, of the oil companies or of the circular in attempting to transfer these customers of mine. My lord, I call upon my learned friend to show whether there has even been one complaint against me by any of my customers till date. So they can transfer for better customer service. I have taken great pains, gone to great lengths, put in significant amounts of money, built a fantastic infrastructure to cater to all my clients. None of my clients have ever raised any grievance against me. They're all more than happy to be with me. The case made out in my writ petition, in fact, is my customers are surprised that they now have to go to some other distributor, and they're unhappy about that. So, my lord, without conducting this viability, assuming, my lord, they have the right in terms of this manual, firstly, my lord, it is not mandatory. Secondly, my lord, an examination has to be done. A report has to be prepared. A feasibility has to be done. Only thereafter. My lord, we kindly then see, my lord, a few lines later, the paragraph after those numbers are mentioned, my lord. In order to ensure that the distributors operate within the defined ceiling limits as identified above, whenever new proposals are established, customers, in the extent to bring the old distributor within the ceiling limits as described, as directed by the oil corporation, will be transferred to the new distributor. Today, my lord, what is under challenge, my lord, is the circular, the 2025 February 21st circular. The oil companies, my lord, are not relying on this manual to transfer these customers. Had they done so, my lord, then I would have had to perhaps challenge or bring to your lordship's notice other grounds of challenge so far as this particular provision in the manual is concerned. Today, it is their clear, unequivocal case that their attempt to transfer any customer is on the basis of the circular. So therefore, my lord, what is under challenge before your lordship today in this petition is the circular itself. Mr. Nag tried to say, my lord, the manual is not under challenge. The manual gives me the right. I say two things. Firstly, the manual does not give you the right. Secondly, the manual gives you a right only upon certain tests being carried out by you. And thirdly, the power out here is being exercised by the circular and not by the manual. So therefore, the manual is under challenge. And kindly bear in mind, lordship, my lord, there is a contract between two parties. On the one hand, my lord, is a sole proprietor, an individual. On the other hand, my lord, is not any ordinary corporate or any ordinary company. It is nobody else but the state itself. Even though it is a contract between the state and one party, that does not mean, my lord, that gives it the state the unfettered right to act arbitrarily and act as per its whims and fancies. Even in contractual disputes, my lord, there is an additional responsibility or an additional burden cast upon the state to ensure that all its actions, all its decisions meet the tests of the Constitution. They cannot violate Article 14 or any article governing my fundamental rights, even though there may be a contract in their favor. They have to still stand the test of the Constitution and the rights given to me. So, my lord, these are my submissions so far as this gas manual is concerned. Now, my lord, some other submissions were made yesterday, and thereafter I'll come to today's submissions, my lord. My lord, I'll just show those two judgments, my lord, where, my lord, it has been held, my lord, that the companies, who the customers belong to. One is, my lord, your lordship's judgment only, my lord, paragraph 24. Kindly give me a moment, my lord. I'll hand over a copy of the same. This is your lordship's judgment. Kindly take para 24 at page 9 of your lordship's judgment. This point has already been considered and dealt with by your lordship. I am of a view that customers are the assets of a business which earned through their business reputation during long unblemished business relation between the dealer, me, and customers. Such relations between the dealers and the customers cannot be curtailed by the corporation by strength of the dealership agreement or by strength of any circular. Her hard-earned achievements of dealer to collect the customers is the sole property and prerogative of the petitioner, that is the distributor. Thus, transfer of customers and policy thereof appears to me irrational and unreasonable. So, your lordship has dealt with this argument. Today, my lord, we are trying to beat a dead horse over and over again. My lordship will kindly also take, my lord, the Bombay High Court judgment, which I have annexed, my lord, at page 62 of my writ petition. And my lord, my learned senior friend also rightly points out, I should have pointed that out. Your lordship's judgment, my lord, has been affirmed by the division bench as well. So this point also, my lord, has been upheld and approved. Now, my lord, will kindly come to the Bombay High Court judgment. I will kindly come to page 74. Kindly come to 75, my lord. Towards the bottom, my lord, the last paragraph at page 75. Bombay High Court, my lord, also has considered this aspect about customers. A careful reading of this clause clearly indicates that the petitioners act as the principal and not as an agent of BPCL as contended by Mr. Sancheti. Faced with this clause, Mr. Sancheti sought to argue that this clause specifically deals with the acts and omissions on part of the distributor and is essentially to seek a safeguard against possible vicarious liability. In our view, the said clause 17 is not restricted to matters of liability, but attends to all contracts or engagements entered into by the distributor with their customers for sale of LPG and or the sale and or installation and or repairs of appliances and or connections thereof with LPG cylinders, filled or empty, and or refills and or pressure regulators and or attached equipment. This is clear from the language used in the said clause. In our view, this is very important, BPCL cannot on one hand absolve itself of any and all acts and omissions by virtue of its distributors being principals, and on the other hand, for the purpose of defending the impugned circular, contend they are agents. In view of the above, we are unable to agree with Mr. Sancheti's argument that the petitioners are only agents of BPCL and cannot claim any vested rights over the customers. So, my lord, I have also shown, my lord, the clauses in my agreement, my lord. Similar clauses are there, my lord, where they say, yes, so far as liabilities are concerned, distributor, it's your headache, but otherwise, they are my customers. This submission, my lord, has been clearly negated by the Honorable Bombay High Court, and there has been no interference with the same till date by the Honorable Supreme Court. Well, the next point which was addressed or sought to be contended by Mr. Nag was with regard to the 2018 circular. Now, in this writ petition, my lord, I have directly challenged and prayed for certiorari, quashing, etc. of the 2025 circular. I have sought for a reversal of the customers who have been transferred pursuant to the 2025 circular. So far as the 2018 circular is concerned, my lord, customers of mine have been transferred based on the 2018 circular. I have sought a retransfer back to me, my lord. Mr. Nag is right. I have not asked for a quashing or any certiorari in respect of the 2018 circular. According to him, this is fatal to my prayers or to my writ petition. My humble submission is, my lord, I am not required to make any prayer, my lord, so far as quashing that 2018 circular is concerned. That has already been quashed. That has already been quashed. The same thing, my lord, cannot be quashed multiple times over. That has been quashed by various courts, including by this honorable court as well. So today what I am praying for, my lord, in respect of a quashed circular, whatever action has been taken by the oil company pursuant to a circular which has been quashed, that action must necessarily be reversed. If some action has been taken by them on the basis of a circular which was subsequently quashed, naturally, if the base goes, any action taken by them on the basis of the circular which stands quashed, that has to be reversed. That is why, my lord, there is no prayer so far as quashing of the circular is concerned, but there is only a prayer for a transfer back of those customers who had been transferred pursuant to the circular. So that, my lord, is a simple answer to that point of theirs. Then, my lord, today, my lord, in the morning, Mr. Nag has again addressed this court for a long while, my lord. He has at the initial stage, my lord, handed up that application form, my lord, which I have addressed and dealt with. And he has handed up, my lord, three order copies of the Honorable Supreme Court in respect of the SLP which is pending against the 30th September 2019 judgment of the Bombay High Court. My lord, what is of significance, my lord, is perhaps, my lord, only the 28th January 2025 order, which your lordship has seen. And, my lord, may I place it once again? Just the last page, my lord. Mr. Tushar Mehta, the learned Solicitor General of India, appearing for the oil marketing companies, submit that perhaps this court need not have to adjudicate these petitions on merits as they are coming out with a new policy. So, in effect, what he is saying, my lord, is since they're going to come out with a new policy, the challenge to the 2018 circular becomes infructuous. So, in other words, the Bombay High Court judgment stands. It stands confirmed, and the SLP will be dismissed. So, these orders, including showing that this SLP is still pending, my lord, does not in any manner come to the rescue or to the aid of the oil company in our case before your lordship. None of these orders say, my lord, that the Bombay High Court judgment has been stayed or that they're enjoying any stay. In fact, to the contrary, these orders come to my aid, showing that the 2018 circular is being admitted by the center to be bad, which is why they are compelled to come out with a new circular. And that new circular now has to stand the test of the court, which is what your lordship will be deciding, which is what other high courts will also be deciding. And they are engaging, my lord. They have passed, my lord, stay orders, my lord, in 5 or 6 different high courts. Mr. Shahare, my lord, has shown some judgments and orders passed by the Bombay High Court. I have shown Kerala, Andhra Pradesh, etc., Cuttack. So, my lord, that is so far as these 3 orders passed by the Supreme Court are concerned, my lord. My humble submission, my lord, they have no impact whatsoever so far as passing of orders in the present writ petitions are concerned. Now, my lord, so far as today morning's submission are concerned, my lord, one of the arguments which Mr. Nag made, my lord, that, my lord, there is a loss of business on my part, which I have addressed, my lord, and therefore it is not maintainable. My submission is, yes, there is a loss of business, and ultimately that will lead to the viability of my business coming into the picture, and therefore my entire business having to come to a standstill, which is why, my lord, my rights under Article 19 crop up. And therefore, this writ petition is maintainable on the platform of Article 19 also. In addition to Article 19 is not the only ground which I am urging. I am primarily also urging, my lord, Article 14, arbitrary, which is what has been held by the Bombay High Court and also by your lordship in the earlier judgment. Next, my lord, a lot of judgments have been cited, my lord, on the point that a policy cannot be the subject matter of a writ petition. Now, my lord, it is well settled that typically, yes, policy matters cannot be subject matter of writ petition, my lord. Judgments also, my lord, which have been cited by Mr. Nag, my lord. I am not joining issue out there, my lord. But all those judgments, my lord, say that, yes, policy matters are typically matters which will not be interfered by the court. But all these judgments also carve out exceptions or exceptional situations when policy matters become the subject matter of judicial review. All the judgments clearly say that, yes, If it is arbitrary, if it is unreasonable, then a policy matter can also come under the scope of judicial review. And that is precisely the reason why the 2018 circular, although being a matter of policy, also came under judicial review scrutiny, including by your lordship, including by the Bombay High Court. And now, of course, the matter is pending before the Supreme Court unless they decide to withdraw that SLP. So, my lord, this argument, my lord, also stands on no legs, that a policy matter cannot be the subject matter and therefore the writ petition should be dismissed. Yes, this policy can be challenged on the ground that it is arbitrary, it is irrational, it is unreasonable, it is discriminatory. There are cases of, a case of estoppel is sought to be made out of by me, a case of legitimate expectation is sought to be made out by me, and of course my right under Article 19 is also sought to be made out by me. Now, my lord, there were also submissions made, my lord, saying that it is my contention that this policy has been brought in to balance the market. That is, my lord, their case, that they are trying to balance the market, bring out new distributors, and take away my customers. That is my allegation against them. I have only said in my writ petition as to what they have claimed in respect of their circular's concern. The other argument, my lord, is, my lord, that I am apparently, my lord, seeking enforcement of my contractual rights, which I cannot do in a writ petition. No, I'm not doing that, my lord. I'm not at all attempting to make, my lord, a case of specific performance or a case of enforcement of my contractual rights. The only case which I'm attempting to make out before this honorable court is whether or not this circular is valid in the eye of law or not. Whether or not this circular is violative of Article 14, 19, and 21 or not. That is my case. I am not trying to seek enforcement of my contract. There is no question of approbating and reprobating at all. That I've dealt with, my lord, in my respect to, in my arguments, my lord, when I was dealing with the clauses with regard to the LP gas manual. Now, my lord, another argument which was sought to be made, Mr. Nag tried to create or give an impression that if today a new distributor is approved, I will make the same arguments. No, that is unfair, my lord. That has never been my case. If a new distributor is appointed, I can have no grievance against the same. That is only fair in accordance with the Competition Act, etc., etc. Nobody is entitled to any monopoly. My grievance is whether or not my customers or clients can be forcibly taken away. The contract also says, and I've signed it with open eyes, that yes, you can appoint new distributors. You can appoint new distributors in my territory. Please go ahead and do that. But please also at the same point of time, do not take away my customers, because you have no right whatsoever to do that. That is violative of my fundamental rights. That is my case. Well, Justice, your lordship's judgment, as your lordship knows, my lord, went up before the division bench, and my lord, the lordship's judgment was upheld. And thereafter, my lord, the matter went up in review also before the division bench. That review was also dismissed. May I just bring that to your lordship's notice? My lord, counter judgment. This is the judgment, my lord, which was initially passed by the division bench. Then, my lord, the review, which came up before the division bench. The review was also dismissed. And lastly, my lord, there was a correction, my lord, typographical error, I think, which was sought in so far as the order, review order is concerned, my lord. I'm handing over the same also, my lord, for complete records. One last sentence to conclude, my lord, which I've said earlier also, my lord. If I perform the attitude of the oil company is, if you perform well, Mr. Distributor, you will be punished. Your customers will be taken away by me. And continuously. It's a continuing threat at all points of time, my lord. That, my lord, is grossly unfair. These are my respectful submissions, my lord. Kindly pass, my lord, interim orders, my lord, protecting me.
But I will only indicate the interpretation given so far as the manual that I have referred. Only that. My learned friend has referred to page number 3 of the manual to show that which is mandatory and which is just directory.
Page number 5.
Page,
The word should.
yes, page number 5. But kindly see one. This manual has different section. Kindly see the page number 1. Page number 1 is technical section. The first part is technical section, page number 1. Now, next page, clause 1, 2, 3. So, like the clauses which are applicable for this particular section, technical section. Then the pages are also given and different issues were also given, which is to be dealt in this particular section, the technical section. And so far as page 5 is concerned, the introduction, this section kindly says this section. It starts with saying this section contains directions. So this particular issue, this section, this is only restricted to page number 5, the first paragraph. This is restricted to this particular section. Now, would you kindly consider this section that I have relied? Page number 5, my lord, which my learned friend has relied at top. This section contains, so this is the paragraph which was relied by my learned friend to refer what is must and how must should be dealt with and should be dealt with. So far as this particular section is concerned, this is only applicable for this section which deals with the technical section. Now kindly consider the section that I have relied. Kindly see page. The first section ends at page 51. The technical section ends at page 51. So this is page 851 is the end of the first section. Then page 53 deals with the next section. Kindly see page 53. LPG gas manual marketing. This is a different section altogether, page 53. Then come to the next page, 55. This section of manual is designed to provide LPG instructions. So similarly, like these notings are also there in the first section. I have shown page number 2. And in this section also, these are there. Then next, what are the things which will be dealt in this section? Marketing, administration, sales, supplies. And then the administration comes, the index. And this section starts at page 60. So far as this particular section is concerned, there is no such explanations given. What my learned friend has shown, that is only restricted to the first section, which is for the technical section. So far as this section is concerned, to which I have relied, there is no such instructions as to so far as how word should or must to be considered.
Okay, my lord, I'll just take 30 seconds to respond, my lord. Should cannot have different meanings in different sections. Number one, if Mr. Nag can bring a dictionary and show that the meaning of should is mandatory, my lord, I'll concede my case right now, right here. Should is always discretionary, whether it was mentioned in page 5 or whether it was not. Kindly ignore page 5 where required. Kindly see the meaning of should.
Okay.
And the oil company cannot say should in one section will mean one thing and in a different section will mean something else.
The argument, Reliance.
If the oil company is confused about the meaning of words, Kindly record that, my lord.
Okay, okay.
Same word will have different meanings in different sections.
I
It's
must
an absurd argument.
I must appreciate the submission advanced by Mr. Bagadia. He has covered everything. I shall just take 5 minutes.
Mr. Medora.
What do you do, Mr. Bagadia?
I'm afraid also, my lord, so far this subject is concerned, he is encroached, my lord. So far this matter is concerned. Must appreciate his submission.
Grateful to Mr. Shah.
Well, just 2 minutes. 3 minutes initial. Since your lordship is going to pass the order considering all submissions, Mr. Nag has advanced some further submissions. Is one of the submission was, my lord, contract may be terminated. When contract may be terminated? Fine. Cause something detrimental to the interest of the petrol company. I am running my business 3 decades, more than 3 decades. 85. Not a single allegation has ever been raised. No complaint has been raised by any of the customers out of 10 to 12,000. No postings ever. So question of termination of absorbing the right means, my lord, when I shall do something wrong. In this case, for 35 years, they never says your performance is not good. Rather, they have always satisfied and says you are performing good because you have increased the numbers of customers as per our dictate. My learned friend has already submitted, my lord, service. Whose customers? Who are providing the service? According to my learned friend, my lord, oil companies providing the service to the customers. What they are doing? They are taking money from the customers and giving me to commission only for the purpose to provide service to the customers. Entire service. Delivery of starts from the enrollment, my duty. Delivery of cylinders, my duty. If there is any leakage, any complaint, it is my duty. Even, my lord, if any accident is happened, I should be responsible for that. So entire service is being provided by us, and according to them, that is their customers. Entire service. The first argument, it has also been argued, my lord, that volume of business, not the entire business is taken up. I have philosophically take up my repetition once. That is item number 1 possibly. Right? What is my pleading? And they have also pleaded the same.
Item number 1 টা দাও। Item number 1.
গৌতম বাসু।
Kindly turn to page 6, paragraph 8. What case we have made out? Specific pleading. Page 6, paragraph 8.
Yes.
Your petition states that it is the practice of the officials of the respondent oil company to deliver excessive LPG cylinders in the godown of your petitioner beyond the official storing capacity, having shortage of space in the godown of your petitioner, and the HPCL authority fixed excess targets. Your petitioner further states that to meet these unreasonable targets set up by the respondent oil company, your petitioner has to enhance infrastructure of his distributorship by engaging more manpower, delivery boy, transportation, etc., to explore more customers within the area of operation of your petitioner. Your petitioner states that your petitioner has significantly enhanced the infrastructure for managing larger number of business, volume of business, and your petitioner has increased capital, manpower, and infrastructure to improve the customers based on the legitimate expectation of not only retention of the existing customers, but also to customers will be increased in future. Your petitioner states that to increase the said APIC distributorship business, your petitioner has invested huge amount of money by taking loan from various sources with huge rate of interest. Your petitioner states that after enhancement of all infrastructure in respect of the LPG distributorship business, your petitioner enhanced the consumers and distributed LPG cylinders to tax customers with their full satisfaction by providing time bound service and no complaint and or allegation has never been raised against your petitioner in regard to running the LPG distributorship business of your petitioner. So submission which has been sought to be advanced, that only at the initial point, at the time of getting license, I have invested the money. Thereafter, no. I have to invest further money for enhancing the customers by engaging manpower, delivery boy, and purchasing vehicles. The delivery vehicles I have to purchase as per their instruction. Now, one fine morning, without any complaint, without any allegation, your 2,000 customers I shall take and I shall provide it to somebody else who has no role to play, who has never tried to enhance his customers. He will be benefited for my performance. Well, judgments have been relied on some judgments. If you will also kindly take up the first judgment which has been read in Azizur Rahman, the state of West Bengal. Kindly take up. What is the cause of action? Is a coordinate bench judgment.
Yes.
Second paragraph, first page. The petitioner was the operator of Fuji passenger ferry car. Lease period of the petitioner had been ended on so and so. The petitioner submits until the ferry car is settled by way of open tender. The petitioner must be allowed to operate. Kindly see the cause of action there. A ferry car has been given to somebody. He completed his job. In the meantime, next tender has not yet been confirmed. He came before this honorable court till the new person is appointed. I should be allowed to continue. That's the court held, my lord. Last paragraph, if you want to kindly turn up. This is the cause of action. Here, Justice Shankar Sarkar held that you have no vested right to continue after completion. The second judgment, which has been relied on before Tata Cellular, your lordship knows. In Tata Cellular, in all cases, there is a parameter and relaxation also. That for this ground you can come to challenge the policy decision. Now, your lordship, kindly next judgment has been relied on 2002, volume 2 Supreme Court cases, page 45.
Balco.
My lord. 22. Well, kindly come to here relied on paragraph 45 and
45 and 46.
Well, kindly turn to paragraph 46, last 3 lines. That's 10%. I'm reading paragraph 46. The sentence starts, nor are our courts, 46.
Yes.
Nor are our courts inclined to strike down a policy at the behest of the petitioner, merely because it has been urged that a different policy would have been fair or wiser or more scientific or more logical. So, proposal has been given, you should frame the policy like this. State has not done so. It is not the duty of the person concerned. It is not the duty of the court to advise the authority to frame the policy like this manner. This is the judgment. The next judgment, 2004, volume 7, SEC, paragraph 16. Volume 7, SEC. Violation of fundamental right. It's not with me.
2007 volume 4.
Malad,
7
malad,
volume.
malad.
Director
This is
of
also
Film
violation of fundamental right. If there is a violation of fundamental right, paragraph 16, if you want to kindly turn up. We have categorically stated this is violation of fundamental right. Article 14, Article 91G, as well as Article 21 on livelihood, 300A. All on a sudden, you are trying to reduce the volume of my business. Article 91G, with no uncertain term, says it is the fundamental right to do lawful business. You are curtailing my business without any providing opportunity. Well, all the judgments almost my lord same grounds. Just I shall support the other judgment. Only to distinguish this judgment, my lord, I have placed this judgment prior to your lordship also. The parameter which has been fixed by the Supreme Court. But Bijmohanlal 2012 volume 6 Supreme Court cases, these are all considered, my lord, Tata Cellular, every judgment. Paragraph 100 and 101, I am reading these things, my learned friend was not present. Certain test whether this court should or not interfere in the policy decision of the state, as stated in other judgments, can be summed up as if the policy fails to satisfy the test of reasonableness, it would be unconstitutional. The change in policy must be made fairly and should not give the impression that it was so done arbitrarily or ulterior intention. The policy can be faulted on grounds of malafide, unreasonableness, arbitrariness, unfairness. If the policy is found to be against any statute or the constitution or runs contrary to the philosophy behind this provision, if it is divorce the provisions of the act, if the delegates has acted beyond its power of solution. But this is unfair, unjust, unreasonable. And paragraph 101, cases of this status can be classified into two main cases. One class being the matters relating to general policy decisions of the state, and the second relating to fiscal policy of the state. In the former class of case, the courts have expanded the scope of judicial review when the actions are arbitrary, malafide, or contrary to law of the land, while the later class of cases, the scope of the judicial review is far narrower. Nevertheless, unreasonableness, arbitrariness, unfair actions of policies contrary to the letter intended of the philosophy of law and policies expanding beyond the permissible limits of delegated power will be instances where the courts will stop in return as well. I'm handing over the copy of the judgment. This judgment possibly in Lordship chamber 4 and 5 in other matters I have also on Bijmohanlal. Now, my lord, before conclusion of my submission, that today your lordship has any option but not to pass any interim order. Kindly take up one judgment has been placed before my learned friend. This is my lord. Kerala.
High Court of Kerala.
High Court of Kerala, my lord. In the High Court of Kerala, the 16th day of April, cost title is not there. Justice Amit Parawal and Justice P.M. Manoj.
Cost title is All India.
All India LPG Distributors Federation, Kerala Circuit. Yesterday, my learned friend has placed this judgment. There are 5 judgments, orders we have placed from different division bench, all different division bench. And so far, Mr. Mr. Mukherjee is concerned, he has relied on only one judgment. So far, the Kerala is concerned, single bench. Kindly take up this judgment, my lord. Page 5. This is an order. Kindly see why I am saying, my lord, this is kindly see top judgment. This is a judgment. This is not an interim order. Although interim order has been passed, but the court says it is a judgment. Page 5.
আইটেম নাম্বার 1 এর সঙ্গে যেগুলো দিয়েছিল কাগজগুলো সব কাগজ এখানে দিয়েছে
Malad, may I hand over another copy? I have an spare copy. This is spare copy. Ready. Malad, can you take up my copy? I have extra copy.
Okay.
Page 5, my lord. Malad, the first thread and kindly is 16th day of April, judgment. Have a lordship. Fine. Page 5. It is not an order. This is a judgment.
Page 5 টা এখান থেকে চলে আসছে।
এইভাবে হচ্ছে কেন?
এইভাবে মানে অনলাইনে যখন
Yes.
Malad, see why I am relying this. Specially, this is a judgment I am reading. The present writ appeal is directed against the interim order dated so and so, whereby the party of the petitioner seeking stay of remand so and so. So this is against an order of the learned single judge refusal to grant any interim order by the division bench. Whereby the pair of the petitioner seeking stay of the implementation of the XP policy dated 21st February 2025. Restructuring of the distributorship by way of refill policy has been declined. So refusal was under challenge. It is contended that an earlier point of time, different oil companies dealing with the distributorship of LPG gases had come out with a policy dated 4th January 2018, giving certain parameters for the purpose of, so far we are concerned, 9th January 2018. Purpose of restructuring the market of consumers vis-a-vis the existing LPG distributors. The state policy was under challenge in various high courts. The High Court of Mumbai in WP number so-and-so by judgment dated so-and-so was the said 2018 policy vis-a-vis the challenge of restructuring. It is matter of record that the said judgment is under challenge before the Honorable Supreme Court without any interim stay. Similar policy was under challenge in this court by writ petition number so-and-so. Upholding the policy in question, the matter is also pending consideration. Keeping in view the judgment dated 30th September 2019, the respondents came up with a new policy of 2025, whereby the Minister of Petroleum had approved the changes in clause 2.4.1.1.1 Note 1 under the Notes of Unified Selection Guideline by letter dated 22nd February 2025, wherein on the basis of the grant market environment and LPG scenario in the country, revised customer transfer norm for restructuring were directed to be followed in different manner than it is in 2018 policy as well as 2016 guideline. It is contended that the 2016 guideline pertain to new LPG distributors, but by 2018 policy, though under challenge and as well policy of 2025. The existing distributors are also brought under the umbrella, which could not have been brought into consideration. Similar policy has been under stay by the High Court of Odisha, Kotak in various writ petitions in the Nagpur bench by order dated so-and-so, as well as on the writ petition of the Patna High Court in the so-and-so. It is contended that once the same policies are under challenge in various other high courts, it would apply pan-India in view of the order of the Supreme Court. Tally take note of. All India Jomital Currency Action Committee through its President Mohammad Abul so-and-so versus Union of India in WP number so-and-so. It would create an anomalous and decontamination situation, and the petition cannot be permitted to remain in quandary. So observation of the division bench, it is binding effect. On the other hand, Advocate Pauluso so-and-so Abraham, the learned counsel appearing on behalf of the respondent 224, submitted that the order under challenge declining the interim stay is perfectly legal and justified, as the same very clause in 2018 policy was not found in favor of the various judgments of this court. Whereas, on the contrary, the High Court of Bombay had set aside the matter is pending before the Honorable Supreme Court. Though there is no interim stay and the opposite of the grant of so-and-so, we have heard the learned counsel for the parties and apprised the paper book. The opening line of the policy dated 21st February 2025 reveals that the Minister of Petroleum had revisited the clauses as mentioned above the 2018 policy, which was subject matter of challenge in erstwhile litigation, and again had brought the existing LPG distributor under the umbrella, whereas the guideline issued 2016 shall remain in vogue and have not undergone any sea change. Therefore, under the grab of those clauses, the existing distributors cannot be disturbed, violation of Article 19 and 300 of the Constitution of India. Considering the attending circumstances and as far as the condition of interim stay, that is prima facie balance of convenience, as also following the interim orders passed by various high courts, we ordered that during the pendency of the repetition so-and-so policy number so-and-so will remain under stay. But kindly pause for a moment. But this is the judgment I have shown to your lordship. This is not judgment in persona. This is judgment in rem. It is applicable to all. In all over India, circular dated 21st of May has been stayed by the division bench. After issuance of any curtailment, restructuring, customer taking is contempt upon, and that is the void and ab initio. This order still exists. The circular has been stayed in all over basis, pan-India basis. There is no question of using this circular anymore. Unless, my lord, kindly see the next page, page 9, the appeal stand disposed of. It is made clear that the aforesaid view is prima facie one shall not be constituted to be an expression of opinion. We are subject to the fact that the counter representing the party will get the answer. So that petition is still pending. So interim order is still there, staying the operation of the circular. After in pan-India basis, a stay has been granted by the division bench, question of curtailment or question of restructuring policy, using the restructuring policy, transfer of any customers is void and ab initio automatically. So these are my submission.
Okay.
I have already submitted before your lordship that it has not been given effect to. Only in the portal. Unless a customer takes cylinders from other distributor, it has not been given effect to. So I am praying before your lordship, status quo ante from the date of issuance of that transfer order. I'm good, lordship. These are my submissions. Yes. And your lordship has already passed the similar order, delivered the judgment, upheld by the division bench, even in review matter. The principle are same, restructuring, transferring of customers from the existing distributor to the new common distributor.
Okay. Heard.
Same wine in different bottle.
Please take down.
Your নামটা বলুন। নাম কি জিজ্ঞেস করুন? Thank you. দেখো ওর জন্য আমি মিস্টেক হয়েছে ওটার কাছে ওটা আমার স্বীকৃতি দিল।
Number 4, the facts in the item number 4 is slightly different, maybe.
Yes.
Alright.
Item number. Your
Four.
item is item number 2, I think.
For today, it's the item.
Your item is item number 2.
The other set of like there are altogether I think 4. Huh? After thinking 1, 3.
1,
1, 3 and 4 is I am appearing.
1, 3 and 4, they are letters by the oil marketing
And
company.
without mentioning any manual or something.
And
And
in
also
your, in the case of item number 2, there are no such letters like.
From the portal that they have transferred.
Okay.
That is
Yes.
And also the I
But
have also
written-
shown the prayers
No
are also
intimator.
different.
Yes.
The prayers are also different. Maybe separately they lack of.
My case is stronger. No intimation also from BPCL.
So you want the separate order like that.
And the order may be common, but that requisition will be separately
Indication
dealt.
will be there. Indication will be there. No issue. Indication will be there. I do not know whether I will conclude. Okay, let's take a first.
আপনি তো reply এ judgment দেখালেন।
তুই যদি
Reply এ judgment
তুই তো ও তো কোনো জাজমেন্ট দেখায়নি মেয়ে ও তো কোনো মেন্টাল গ্রাউন্ডে জাজমেন্ট দেখায়নি
Petitioners
সেটা তো আমার উপর অ্যাপ্লাই হয়ে গেল
are the LPG distributors who are distributing cylinders to the customers who are distributing cylinders of oil marketing companies or particular oil marketing companies to the customers. Full stop. Petitioner challenges policy on customer transfer hyphen market restructuring policy dated 21st of February 2025. Issued by 3 leading oil marketing companies, namely IOCL, BPCL, and HPCL. Full stop. It is the contention of the petitioner that on the earlier occasion, the oil marketing companies had issued previous circular under same nomenclature on 4th of January 2018 and 9th of January 2018 respectively for transfer of for regarding the policy on customers transfer from one distributor to another distributor. The said policy was under challenge initially before the Honorable Division Bench of Bombay High Court in writ petition number in writ petition number 8753 of 2018 within bracket Messrs. Sailaja R. Khanvilkar versus Union of India, wherein when the division bench of the Honorable Bombay High Court has quashed the said circulars dated 4th of January 2018 issued by the oil marketing company, which was under challenge before the Honorable Apex Court by the Union of India. The facts suggest that the said that the Honorable Apex Court has not granted any stay against the order of the Honorable Division Bench of the Bombay High Court and had admitted the SAP for hearing under civil appeal. Full stop. The circular dated 9th of January 2018 was also under challenge. Before this court in writ petition number 20391 of 2023 within bracket MS SLS Limited and others versus Union of India, wherein this court, by the judgment dated 20th February 2025, has directed the said circular to be irrational and unreasonable and directed the concerned oil marketing company to return the customers in favor of the petitioners therein. The Union of India has approached, oil marketing company has approached the Honorable Apex Court against the said order, Honorable Division Bench of this court in the same order, wherein the Honorable Division Bench in MAT number 335 of 2025 dismissed the said appeal and did not interfere with the observation of this court. It is the contention of the next paragraph. It is the contention. A review application was placed by the filed by the oil marketing companies against the said judgment, but said review was also not entertained by the Honorable Division Bench. Next paragraph. At this juncture, the learned counsel for the petitioner submits that the impugned policy dated 21st of February 2025 by the three leading oil marketing companies are the same policy under same policy of 2018 under a new nomenclature. It is the contention of the further contention of the petitioner that as the earlier circular of 2018 is under challenge before the Honorable Apex Court, was quashed by the Honorable Division Bench of Bombay High Court and is under challenge before the Supreme Court. The oil marketing companies has issued new circular for the same purpose. Full stop. Learned counsel for the petitioner submits that this court has already decided the issue that the policy for transferring the customers from one distributor to another distributor is unreasonable. Thus, the said new circular dated 21st of February 2025 is required to be stayed. In support of learned counsel for the petitioner further argued that the said new circular of 21st February 2025 was also under challenge before the honorable before the different high courts, wherein the high courts has issued an order of stay. In one case, the Honorable Division Bench of Kerala High Court has passed an order in an appeal against wherein an interim order was refused. In the said appeal, being number WA number 776 of 2025, the Division Bench of the Kerala High Court has issued an interim order on the observation that as various High Court has granted interim stay, thus the same should be followed. During the pendency of the writ petition, clause number 2.1, 2.4.1.1.1, note within bracket 1 of policy 2016 what's 2025 2016 Corban 2025 remain state full stop. It is the further contention of the petitioner that this court has specifically observed on the earlier occasions that the customers are the assets of the distributors, which has been approved by the Honorable Division Bench. So at this juncture, this court cannot but pass an interim order staying the operation of the circular dated 21st February 2025 and the subsequent letters by the oil marketing company for transfer of number of customers from the database of from the customer base of the petitioner to other distributors. Full stop. Learned counsel appearing on behalf of the oil marketing companies has extensively argued regarding the area and periphery and ambit of the distributors under the agreement with the oil marketing policy to conduct the business of LPG distributorship. It is the contention of the learned counsel for the oil marketing companies that the customers are using the product of oil marketing company which and they are registered under the particular oil marketing company. Full stop. The distributors are the intermediaries who at the instructions of the oil marketing companies are distributing the liquefied petroleum gas to the customers for domestic use. Full stop. It has been specifically argued by the learned counsel for the oil marketing companies that at the time of entering into the agreement with the oil marketing companies, the distributors has unequivocally undertook to carry out all the directions and orders of the oil marketing companies and also carry out the formalities and the principles laid down in the LP gas manual. It is the further contention of the learned counsel for the respondent authority that in clause 12 it has been specifically dealt with that each dealer should faithfully and diligently observe and carry out all directions, orders and terms and conditions as may be issued by the corporation within bracket oil marketing company from time to time, which was contained in the corporation's HP gas manual. Full stop. It has been the full stop. The HP gas manual has placed before this court particular provisions of the HP gas manual was referred, wherein the surrender of area and customers and ceiling limits of each and every distributors and rights thereof has been reserved by the oil marketing companies. It is the contention of the learned counsel for the respondent authority that the oil marketing company at any time at the through the power of the HP gas manual may transfer any customer to the customer from one distributor to any other distributor. Full stop. It is further argued by the respondent authority that the policy decision was taken by the Union of India regarding restructuring of the market, by which the Union of India intends to eradicate the monopoly of some specific distributors in catering the business. It is submitted that the competition in the business will benefit the service of the customer. On that score, the Government of India has issued the circular so that the customers may be benefited for better service. Full stop. It is the other link of submissions of the learned counsels for the respondent that policy decision of a state, policy decision of the central government cannot be put under question in a writ jurisdiction. Full stop. It has been specifically argued that the Honorable Supreme Court in several decisions has put a self-restrictions in interfering with the policy decision of the government. In support of which contention, learned counsel for the petitioner, learned counsel for the respondent authority has placed decision of Honorable Apex Court in Tata Cellular versus Union of India, reported in 1994, 6 Supreme Court cases, 651. Next para, Balco Employees Union versus Union of India, reported in 2000, within bracket 2002, 2 Supreme Court cases, 333, full stop. Next para, Directorate of Film Festivals and others versus Guru Basin Jain and others, reported in 2007, 4 SCC 737. Next para, Rajasthan State Industrial Development and Investment Corporation and another versus Diamond and James Development Corporation Limited, reported in 2013, 5 SCC 470. And the Nagar NAGAR, rice and flour mills and others versus N Tikappa, TITEEKAPPA, Gowda, GOWDA, and brothers, reported in 1970, 1 SCC 575.
Rajasthan was on the different issue. One of the Rajasthan was not on the policy, right? That was on the issue that
That is a Nagar rice.
Rajasthan matter. That was on the issue that receipt offers on the contract. You can't
Okay. Remedy otherwise.
No, you can ask for receipt offers one clause of the contract and in isolation
Okay.
of the other.
Hot and blow at the same time.
Right.
Full stop. ওই তাহলে রাজস্থানটা একটু বাদ দাও, কাটো, রাজস্থান স্টেট ইন্ডাস্ট্রি বাদ দাও, ঠিক আছে। In Tata Circular, the Honorable Apex Court had set out some principles where a writ court can entertain petitions in respect of the policy of a government. They are as follows, paragraph 94. Set out court. Paragraph 94, page number, hold করে রাখছি, page 37. In Balco Employees Union Supra, the Honorable Apex Court has also embodied some principles regarding judicial restraint in policy decision of a state. Paragraph 45, 46, set out call, page 38. In Directorate of Film Festivals and others, the Honorable Supreme Court has also dealt with scope of judicial review on government policy as follows. Paragraph 16, set out code at page 10. In Nagar Rice and Flour Mills, Supra, the Honorable Apex Court has dealt with the fundamental right of the citizens enshrined under Article 19(1) within bracket G of the Constitution, which can be exercised subject to the restrictions under Article 19 within bracket 6 within bracket Roman 1. Full stop. Learned counsel appearing on behalf of the oil marketing companies next particular further argued that the issue which was dealt with by this court and the Honorable Division Bench of the Bombay High Court is this similar to that of the present issue. The circular of 2018 is totally different to that of the circular which was issued by the state in the year 2025. Full stop. On the earlier circular, the viability limit was 75%. 75% of each distributors, but now the viability limit of the distributor was taken to be 100%. Thus, this particular is totally different. The earlier judgments and the observation of this court cannot be followed in this case. He further submits that when the viability limit of a distributor were fixed to be 100%, thus it can be said that the business of the distributor cannot be taken away by the impugned circular. It is the contention of the learned counsel for the respondent authority that justification and necessary to issue such circular can be very well demonstrated before this court if the respondent authority is granted a leave to file supplementary affidavit in opposition against the writ petition. Full stop. However, as the business of the petitioners was not at all hampered by the impugned circular, that is to say, their license has not been cancelled. Thus, the petitioners are not suffering by the said circular. Full stop. It is the further contention of the learned counsel for the respondent authority that the petitioners are performing business on the basis of the agreement entered into by the petitioner and the oil marketing companies. They are catering business by the strength of the said agreement. At the same time, they cannot challenge the some provisions of the said agreement while they have agreed and signed the said agreement. On that principle, the learned counsel for the oil marketing company has cited the decisions of Rajasthan State Industrial decision of Honorable Apex Court, reported in Rajasthan State Industrial Development and Investment Corporation and other versus Diamond and James Development Corporation Limited, reported in 2013, 5 SCC 470. Paragraph 19, set of code. It has been further contested by the learned counsel for the respondent authority that though the judgment passed by the Honorable Division Bench of Bombay High Court is under challenge before the Honorable Apex Court, but there are some observations of different High Court in respect of the said circular of 2018, wherein the different High Courts has allowed to carry on the said circular. Full stop. He submits that as the decision has not been, it has been further submitted that as the decision has not been arrived at by the Honorable Apex Court, thus the submission of the learned counsel for the petitioner regarding finality of earlier circular date of 2018 is not correct. The learned counsel for the oil marketing company has also placed the orders of Honorable Apex Court full stop. I peruse the order. In the order dated 21st of January 2025, the matter was came up before the Honorable Apex Court. Came up before the Honorable Apex Court for hearing, wherein learned Solicitor General of India has expressed that the oil marketing companies will come up with new policy, and it was taken note of. Very order dated 18th of April 2025, application for permission to file SLP was granted by the Honorable. Application for permission to file SLP was granted by the Honorable Apex Court. It is the contents of the learned counsel for the oil marketing company that the matter is pending before the Honorable Apex Court. Thus, the issue has not been finally decided. It is submitted that the in the instant case, interim order cannot be passed, as the decision of the as the impugned circular is the decision of the Union of India, wherein the writ court cannot entertain. Full stop. Refuting the contention of the oil marketing company, in reply, the learned counsel for the petitioners has also pointed some provisions of the agreement wherein the distributors are forced to enhance their business by supplying more cylinders the learned counsel for the petitioner also referred some clauses of agreement wherein the indemnity clause is only upon the distributors, and also mentioned that the corporation shall bear no warranty in respect of any loss and damages to the customers. Full stop. Under the same guise, under the same submission, it is the contention of the learned counsel for the petitioner that all responsibility of the customers was upon the distributors, and they were also forced to extend their business. By such, they have taken huge loan from the different organizations and expanded their business. Suddenly, by the strength of the circular, if a number of customers was taken away and was given to another customers, obviously the business of the petitioner will be at loss. It is the submission of the learned counsel for the petitioner that the right guaranteed under the Constitution under Article 19(1)(g) has been definitely violated by issuance of such circular. Thus, it is required to be stayed. Issuance of such circular. Thus, it is required to be stayed. Full stop. The learned counsel for the petitioner has also cited a decision of Brij Mohan Lal versus Union of India, reported in 2012, 6 SCC 502, wherein the apex court has categorically observed when the policy decision of a state can be challenged in a writ petition. Paragraph 100 at page 58. Full stop. Next call. Having heard the long submissions of respective parties, also considering the observation of Honorable Apex Court, it appears that much have argued by the parties in respect of the present impugned policy circular of the three oil marketing companies on 21/2/2025. In the earlier policy, which was under challenge before this court, and was decided finally by an order of the Honorable Division Bench, there are a clause that a distributor may retain 75% of refill ceiling limit applicable to them. Full stop. In the present circular, each distributor was directed to retain 100% of their refill ceiling limit Full stop. At the same time, refill ceiling limit of all the distributors for customer transfer has been changed. When for the city towns where the population of 40 lakhs and above, the refill ceiling limit was 20,000. It was came down to 10,000, and town with 20 lakh to 40 lakh population, when it was earlier 15,000, it was down to 77,500. Likewise, the 50% refill ceiling limit and viability limits applicable to the all distributors was down to reduced to sorry কি বললাম বলো না 50% কাটো রিফিল না 50% টা কাটো by the present circular, তারপরে ওই 50% আগে লিখো by the present circular, কি বললাম by the present circular, হ্যাঁ, refill ceiling limit and viability limits applicable for all distributors were restricted to the 50% to that of the earlier ceiling limits. It means though the distributors were directed to retain 100% refill ceiling limit, but the refill ceiling limit has been drastically reduced to 50% to that of the earlier circular. Full stop. Thus, by the said impugned marketing restructuring policy, the distributor, each and every distributor can retain 100% of their refill ceiling limit, 100% customer of their refill ceiling limit. No, 100% customer distributor will retain কি বললাম বলো can retain 100% of refill ceiling limit applicable to them. That means the actual ceiling limit which was there with the each distributor, which was there with the all distributor, was reduced. Full stop. By the strength of the circular, the 3 oil marketing companies intends to restructure the market of LPG liquefied petroleum gas distribution amongst the customers for domestic use. Full stop. It has been observed by this court on the earlier occasion that the customer of LPG distributors are the assets of the distributors. Full stop. In deciding the said issue, this court has categorically observed each and every clauses of the agreement. The same issue has again placed before this court. Furthermore, the same issue, this court has taken a decision on that issue, which was upheld by the division bench. At this juncture, this court cannot take a separate decision on the argument placed by the learned counsel for the oil marketing companies. That would be tantamount to be sitting over an appeal by the order of this court, over the order of this court. Furthermore, it appears to me that the several high courts has already stayed the impugned circular dated 21/2/2025. Full stop. This court also cannot pass a different order to that of the view taken by the other high courts. Moreover, the purpose of issuing, moreover, for better appreciation of the matter regarding purpose of issuing such circular by the union, by the oil marketing companies, and whether it is actually for the purpose of for the benefit of the public purpose, or for the purpose to eradicate the monopoly in the market, that would be considered at the final stage. On that score, the oil marketing companies respondent authorities at leave to file affidavit in opposition against the writ petition. Leave to file affidavit in opposition against the writ petition within 4 weeks from date. Reply, if any, by the petitioner within 2 weeks thereafter. Full stop. Considering the full stop. Considering the entire facts and circumstances, and considering the principle of issuance of an interim order, it appears to me that balance of convenience and inconvenience is tilting in favor of the petitioners, as they are hereby losing their customers. Moreover, it appears that as the issue has been taken up by different high court in pan India basis, and in all the matters as referred before me, different high courts has taken the view to issue an interim order. This court has also taken the same view. Full stop. There shall be an interim order of stay of the impugned notification, impugned circular dated 21st of February 2025. Full stop. The oil marketing companies are directed to not to take effect upon any letter or communication to the distributor on the basis of the said circular dated 21st of February 2025. Full stop.
Now 2025.
2025. Okay.
Affidavit issue দিয়েছে?
The next para poro. I am passing a separate interim order in respect of item number 2. Item number ছোট্ট করে দুটো পারা দিয়ে করে দেবো।
মানে কি আমাদের দিতে উচিত? আমাদের ক্লায়েন্ট তো ছাড় যেতে না পারে।
কি করবো?
ম্যাটারটা কি আউট অফ
তাহলে আবার ইন্টারিম অর্ডার আলাদা কেন?
15554. Okay. ওই লিখবে লাস্টে ইন্টারিম অর্ডারের জায়গায় লিখবে আইটেম নাম্বার লিখবে WPA 15554 of 2025 এইখানে কিছু অ্যাড হবে বুঝছে Learned counsel for the oil marketing companies further argued that in this writ petition the earlier circular of the oil marketing company for the year 2018 was not under challenge. He submits that by the strength of the said circular, the concerned respondent oil marketing said circular of 2018, the oil marketing company has transferred some of the customers from the customer base of the petitioner to other dealer, other distributor, which was not under challenge. Moreover, no mandamus was paid before this court for to challenge the earlier circular. Hence, the petitioner cannot claim equity on the basis of the order passed by this court on the basis of the earlier circular. Full stop. এবার লাস্টে প্যারা দিয়ে করবে লাস্টে প্যারা দাও learned counsel for the petitioner submits that the circular under 2018 passed by the oil marketing company has already been quashed by the Honorable Division Bench, though the Honorable Apex Court has accepted the SLP, but no interim order was passed against such order. Thus, the order of quashment of the earlier circular against such order. Thus, the order of quashment passed by the Honorable Division Bench of the Bombay High Court has attained its finality. When full stop, though no mandamus was sought for in the against the earlier circular, but the respondent oil marketing company has, without any intimation to the petitioner, has taken away 1981 customers from the customer base of the petitioner. 1918 customers. 1918 customers from the database of the petitioner to the other dealer, other distributors. Full stop. Without any without any knowledge and intimation to the petitioner. He submits that the act and action of the respondent authority is discriminatory and arbitrary, diverse to the provisions of Article 14 of the Constitution of India. Full stop.
Even new transfers were also no mandamus against the current policy of dialysis para where
The new policy is under challenge.
the
February.
transfers under the new
No,
policy.
no. Transfer was not under challenge. Transfer
Transfer
not.
under the new policy is also not under.
No, not
there is there is no mandamus.
Okay.
Interim order, no mandamus against the new.
Okay. Very well.
Your lordship is
Bola.
not passing any mandamus.
Is discriminatory and arbitrary, adheres to the provisions. হয়েছে এবার লাস্টে ওইটা দেবে দুটো প্যারাগ্রাফ তুমি লিখবে আমি বলে দেবো কোথায় ঠিক আছে এবার লাস্টে একদম লাস্ট প্যারাগ্রাফ যেখানে ইন্টারিম অর্ডার করেছি in considering the prima facie case and balance of inconvenience of this matter, it appears to me that the respondent oil marketing companies, after issuance of the circular dated 21st February 2025, had straight away taken away some of the customers from the database of the petitioner without any. Some of the customers of the petitioner and transferred them to another distributor. Full stop. they had no intimation or knowledge to that effect. Full stop. If the said circular allowed to be continued, the oil marketing company may have the right to do so in future. Considering the same, it appears to me that the petitioner has demonstrated a strong prima facie case before this court. Accordingly, the circular issued by the three oil marketing companies on 21st of February 2025 is hereby stayed for a period of 8 weeks from date.
So far our case is concerned, we are also paying
All 8 weeks.
pair H, my lord. So far the curtailment is concerned, that is pair H at page 33.
It has been stayed.
No, your lordship has stated the circular, but so far the intimation that we are curtailing this
That
number
was also stayed.
state, that is pair H.
Yes, I have got it. Okay.
So far as the manual is concerned, we used to extend the manual. That is the only clarification I
Manual, I have taken your submission that you have placed the manual and several provisions. It is within the ambit of the oil marketing company to transfer the. I have taken your note of this submission.
No, your lordship has also stated the curtailment orders.
Yes.
In our cases, there is an order.
That's why there is separate order. Curtailment order is
Your
in
lordship
case there is
referred
no
to
such
pair
order.
H of the three petitions. Pair H, I have stated an order to issue staying the operation of the two emails dated so and so. That has been
Pair H.
my lord, in all.
Okay, I will take it. Okay, thank you.
My lord, before rise.
Lordship, item number 7, Lordship.
Number 6.
Item number 7
second up.
was specially fixed at 12:30.
Item number 5.
So now it is.
If I fix it any other day, will at my other side there, Mr. Talukdar.
Yes, I will come back definitely.
7, Lordship, kindly keep it any other day because
Definitely, I
I
will
have
come
today
back.
a
But I
little
have some
difficulty.
different determinations.
What you all say?
But I think 10:30 matter, one time then fix it any other day, will at
And my lord, 6 is also to be fixed.
next item. Will at
All matters are fixed.
So pair H, your lordship kindly kept it.
Okay.
Other matter. দুটো matter আছে, যে দুটো। তিন চার। But affidavit service filed in all the matters, my lord. He kept not.
Item number 5.
We are also waiting.
Now this matter is going on for 2 days. This matter.
This is the second. Today would have been the second. But for my rejoinder, you need a 5 to 10.
This matter,
Yes, next matter, item number 5, 10:30.
it will appear next Thursday.
And my lord, with regard to item number 6.
Just wait.
You will not raise any new issue.
Lordship, item number 7, Lordship, it was fixed at 12:30. Lordship, kindly keep it any other day, Lordship, as it convenient. Item number 7.
6 হলো না তার আগে।
তো বেজে গেল, এখন তো আসছেই না তো। Continue করবো। Let the item number 5, let the matter appear in the list on 31st of July 2025 at 10:30. Item number 5. I do not know whether any of the matter is fixed or not.
It was also the first matter. It will take 5 minutes of the Lordship.
My lord, with regard to item number 6, just the next matter. My lord, interim order would have been expired on today. Today it was fixed for hearing in 12:30. Interim order would have been expired.
Lordship pleasure to take up this matter on 31st.
Fixed আছে কিছু? কি আছে? 33 and 34 fixed at 2 p.m. Now I can start the matter. নামো না নাকি? পাগল। এর জন্য item number 6.
6, my lord. It was fixed on 12:30 and interim order was still today.
Very good. Item number 6, let the matter appear in the list on 31st of July 2025 at 12:30 p.m.
My lord, 10:30, my lord.
12:30 p.m. And full interim order passed by this court be extended till the urgent date.
My lord, obliged.
Lordship, item number 7, Lordship.
Or no more.
এই ভাই ও ভাই
পাঁচ
Matter 2 PM 33 and 34.
For the respondent.
I am for the petitioner. Yes, who is for the petitioner? I am for the
I'm late by Mr. Ashok Kumar Banerjee, senior advocate, town planner.
very good. So, you have already started.
Already start.
Continue.
Could you kindly give some time? My senior will come.
করতে চাও তো করো করো যাও। Yes, what is the matter about?
Matter is regarding the objection about matter 5A, section 5A. Under the Land Acquisition Act 1894.
Act 1.
Yes.
Act 1.
এটা বের করুন তো রিড পিটিশন কোথায় আর এদিকে সব ছড়িয়ে ছিটিয়ে গেছে
দেখি কোনটা? Affidavit in reply. Affidavit in opposition. I read. এটা ঠিক আছে।
Here for the response number 8.
You have for response number 8.
And myself, the deputy manager. Let's go. Actually, whatever argument they will advance, they will do that, but it's short. Fact is this, property was acquired by the government authority.
Yes.
Because of it. And we are the beneficiary. Today, my friend is applying for the state, is not here. He's the also that. Now, that was challenged. Yes, he has every right to challenge. I also moved several applications. But question is this, how far will be able to substantiate their own contact source, since they won't be able to substantiate the case of not proper acquisitions, they made an attempt to amend these interpretations.
Amend.
Amend it. Petition, read petitions.
Okay, read petition was amended.
No, then it was hard at length by Justice Shaidullah Musi was, and that was rejected. And most interesting.
That was rejected.
Yes.
Read petition was rejected.
No.
Application for amendment was rejected.
But it goes to the root of this case because they are sure the petition which stand at present moment before lordships, they won't be able to. It is my submission. Do not think well, that was I'm just. They won't be able to substitute their case. So that is serious attempt was made to amend the petitions, and Justice Shaidullah Munshi, as he was then was, sitting singly, ultimately rejected that amendment. Now, once it is done, and since it has not been challenged,
Not challenge the order.
then
Okay.
now I just request the lordships to just look into this order of justice. আছে কি ওখানে?
Certainly would be here. Do you have the copy?
I'm trying. Paper book that I think. Paper book দাও, not একটু বার করে রাখ। Very vital.
But more.
So amendment order to paper book দাও তো add. How much? Part 1 does. Very good.
Two case lecture.
So my lord, the part 1, very good part 1. Now there, page 452, and 452 কোন পাতা আছে বার করো? 452 বার করো. My lord, do not find there. They are only description of the document there, serial number 8, Roman 7, that mentioned. The judgment and order dated 12 December 2014, passed by his lordship, the Honorable Justice Shaidullah Munshi, Kannapa, Sergeant Sir, which is report, which is printed in page number 452. Is the work on? Admit down. Take the 452.
Volume.
Madam, I beg your apology. I was thinking of circumstances. That court number
না না
40
ঠিক আছে আপনি না আপনি সব না
ভয় করে তো আপনাকে।
আমার তো ভয় করবি আমি তো অনেক বড় ওই জন্য এদিকে পিছনে তো আমার চিমটি কাটবি নো প্রবলেম কিছু বাদ গেছে মনে হচ্ছে এই তো এটা পেজ 4-5 দেখো তো ভাই 4-5 পাও বলে আছে তো 452 টা বার কর তো পেপার থেকে
অন্য ভলিউমে 452 আছে পেজ, এটা তো পেজ শেষ হয়ে যাচ্ছে 268, এটাতে 452 আছে।
ও শচীন্দ্রনাথ মন্ডল।
সেকেন্ড or থার্ড ভলিউম?
That is very vital because it goes to the root of the case. It's why. ঠিক আছে আজকে না হলে পরের বাকি আছে পেজ নাম্বার তো প্রিন্ট করা আছে পেজ নাম্বার তো একটাই হবে
না দুটো।
ও কোন কেসে?
এটা সেকেন্ড কেস বলছি না, মানে সেকেন্ড কেস।
ফার্স্ট সেকেন্ড যাই হোক, তুমি একটা 1500
I started with first case, last occasion.
হ্যাঁ
15,591, এটা সেকেন্ড কেস। This is Sachindranath Mondol.
থ্যাংক ইউ ভাই। ওটা কত নম্বর পার্ট? পার্ট
দেখে দাও।
3, তাই তো। বার করো না, এরা তো জলচাপ করে বার করো। এই বই দেয়নি, তাহলে বইগুলো এলো করতে। আমার গাড়ি চাপিয়ে দিই। হ্যাঁ 45248. My lord has got this.
Yes, yes.
That is very vital because, as I've already put the convenience of my friend, again I'm repeating my lord. Original petition was more, it's a very scanty my lord. There's nothing. Very rightly they made an attempt, my lord, to improve their positions. And in that amendment petition, they have introduced so many things.
Yes.
Now, Justice just argued at length. Probably I had a privilege to argue in this case, my lord. If I'm not wrong. I also appear. Now, they are ultimately hearing the parties. My lord Justice Munshi rejected their applications. And what is the consequence? It's very
My lord, on earlier occasion, I started with case number 1. Meantime, audio afraid of senior Mr. Banerjee. He's always juggling with 4-5 balls, always one in the air.
Huh?
That I could follow it because second case he's dealing with particular application for supplementary. That has been no doubt. On record, it has been cancelled. Yes, court thought it twice. But where goes my writ application itself? The bone of contention of the writ application is this: the government authority issued notice under section 4. I do believe this notice is bad in law.
Yes.
They applied section 6. We say proper procedure was not followed. Ultimately, 8 year, 9 years, 10 year scheme, according to them, 277 plots in case number 2, what my learned senior had started. Out of 277 plots, only 27 plots have they taken control of it. Wherein that's acres after acres. Authority, it was 2003, it is 2025, during the span of 22 years. And the later thing, 2 or 3 years back. Fact remains, our condition is 17.4. 17.4, they have applied for emergency provision. And they would allow me any opportunity. Section 5A. Then whole crux of the matter, first in 2 matters.
Now, let me understand first. So you have challenged one LA case. Provisions under section 4 notice you have challenged. This is your challenge?
It's totally challenge. Actually, there are 28 petitioners.
28 petitioners. They
1 or 2 cases, somebody appeared. In case number 1, I mean Sachindranath Ghosh, to case number 1, the first case, nobody was issued any notice. We have not received any notice. We are not in the room. We are still now in the dark. But fact remains, we see every day, this is our land. This land is used by somebody, other people.
that is his whole case. Section 4 notice, they are right. So,
Huh?
I will.
Section 4 notice, according to us, bad in law. Actually, to the daily news. Yeah. As I earlier occasion, I read it. I say there was no earthly reason on the part of the government to issue notice under section 74 without giving us any opportunity hearing us in terms of section 5 of the Land Acquisition Act 1894.
Okay, okay.
Milord, sees goes to be a ghost. My lording, the petitioner no one goes.
Request my friend, argue. That is your wisdom. Argue, and my name is always here with patience. Never reply. Everyone is coming and sometimes I also talk nonsense. My lord is mine, or I carry on.
Yes.
Only thing I request you. Well, you can proceed, but don't put it in the wall. Don't put it in the wall. What you know is a Gunda. Because once you put in the hot food, not only even the judges cannot come out. So that's no problem. Just besides, what is your point?
Yes.
First point I have realized, my lord, he has not been served with his taking notice under section 4 and 6.
No, the prayer A says the state has not, what did it say?
The prayer A read
Not
page 22.
thoroughly acquired in accordance with law.
That is the main point.
Not accordance with law within a reasonable time.
And second point, what he has taken, my lord, section 74 invoked, but no opportunity is given to me because I am entitled to have section 5 capital A, that is hearing and other things. Well, I'll answer all these things. I'm not afraid. But how is it? This is your meant to point, if I'm not wrong.
Yeah. If it's so, really, no doubt my lord would allow me to make my submission on this score. I believe there was no need of applying section 17(4) of the Land
No, let me first understand your read petitions.
Read petition.
First prayer A.
First prayer A, page 23.
Yes.
A writ of and or in the nature of mandamus commending the respondents, their men and agents and subordinates, why an appropriate direction should not be given upon the state government in case the said land was not properly acquired in accordance with law within a reasonable time. The land of the petitioner should not be declared free from acquisition, and the petitioner may start the construction of the building for their dwelling purpose.
Yes.
B.
So it is not according to law.
According to law.
That is your first prayer.
First prayer.
Declaring to be not according to the law. And second prayer?
Second prayer, a writ of and or in the nature of mandamus commending the respondent, their men and agents and subordinates, why the impugned notice and notification issued by the state authorities for acquisition of the petitioners without taking recourse to the provision of law in respect of the petitioner land should not be quashed, cancelled, and set aside.
Which notice you have mentioned?
We have a notice I have mentioned.
Notice and notification?
Notice, my lord, please see page 204 of the paper book.
Now, whether this notice were mentioned in the read petition itself?
Read petition.
You have said the impugned notice.
My lord, this notice has been annexed. This notice is of 21/11/2002. But read application was filed in the year 2003. 2259 at the start of the 2003. This notification, my lord, please see page 204. It is Bengali notification is written to 204 to 208. This notification under section 17(4) of the Land Acquisition Act. Under section 17(4) of the Land Acquisition Act. Milord is categorical.
You are referring volume?
Volume, Milord, this is only one volume. First application, goes to Bihari, and other. WP 2259 of 2003. ছোট ভাই, আমি আপনারও ছোট ভাই। আমি আপনার শিষ্য। Milord,
Did you notice how many voluminous paper were like this? I have to carry like this. How is it? Why so many papers? I don't understand. No, should be organization.
no, at that point of time, I was not there, but real estate is these people, they have lost their land and they have submitted 4 থেকে 8. They have submitted documents on the spot at that point of time, which was some
Very voluminous. It's just quite difficult to carry.
and then
Yes.
এইটাই
Got it.
এইটা দেখুন, এইটা
This is part one. देखिए दाও। 225 named W of 2003.
There are two matters, two
Two
sets of paper book that was prepared by my friend. The first he must segregate that. According to him, that well, and he comes with a point, on the argument he can do that. So that court can understand.
Yes.
এখানে একবার ধরছি, ওখানে একবার ধরছি, এ তো মুশকিল।
দিয়ে দাও আমাকে।
সামলাতে পারবো না।
So 2259 is the writ petition filed in the year 2003.
3.
Yes. So it
Did-
is your prayer issuing, challenging a notice and notification.
notification.
What is the date of notice?
Notice 21st November 2002.
Have you mentioned in paragraph writ petition pleadings?
My
Which
lord,
paragraph?
there is a specific amendment that paragraph 15.
Paragraph 15.
uh,
Paragraph 15.
15. Somewhere it is stated, but I do see at the present moment paragraph 15.
21st of November 2002.
Page 18.
Yes, got it.
Your petitioner states that respondents are trying to evade the principles and procures prescribed under law no notification under section 4 or under section 3 was published or served in accordance with the provision of law, namely Act 1 of 1894, excepting some notice published in Ganashakti dated 21/11/2011. That I would see, but 204, that is notice under section 17(4) of the Act. The said publication is not a proper publication, as the said Ganashakti is a mouthpiece of a particular political party and cannot be said to be a local newspaper, and the said publication is not a proper publication.
So this is the first challenge.
The first challenge, all notices we have challenged. The first notice is section 4. Section 4 notification, according to us, this has not been followed by the state. Subject matter of challenge is two things. First, notification under section 4 and consequently section 6 as they executed are not proper. And secondly,
Let me take out the section 4, land acquisition 1984. 1894. দাও দাও। ওই শুরুটা উপরটা শুরুটা। ওইটা ঠিক আছে ওইটা। ওর পরেরটা।
publication of preliminary notification and powers of officers thereupon. Whenever it appears to the appropriate government that land in any locality is needed or is likely to be needed for any public purpose or for the company, in notification to the effect shall be published in the official gazette and in 2 daily newspapers, circulating in that locality, of which at least one shall be in the regional language. And the collector shall cause public notice to the substance of such notification to be given at convenient places in the said locality. The last of the dates of such publication and the giving of such public notice being hereinafter referred to as the date of publication of the notification. 2. Thereupon it shall be lawful for any officer, either generally or specially authorized by such government in this behalf, and or its servants and workmen, to enter upon and survey and take levels of any land in such locality, to dig or bore into the subsoil, to do all other acts necessary to ascertain whether the land is adopted for such purposes, to set out the boundaries of land proposed to be taken and the landed line of the work proposed to be made thereupon, to make such level, boundaries and line by placing marks and cutting trenches. And where otherwise the survey cannot be completed and the levels taken and the boundaries and the marks, to cut down and clear away any part of any standing crop, fence or jungle, provided that no person shall enter into any building or upon any enclosed court or garden attached to a dwelling house, unless with the consent of the occupier thereof, without previously giving such occupier at least 7 days notice in writing of his intention to do so.
So this is the notice.
This
This is the provisions of notice.
provision.
So what you want? What is your objection?
My objection is this. Several times myself, I mean, is the fact. This is one application, it's second application. Everywhere, by learned fact, well enlighten your lordship. Our contest is Ganashakti is the mouthpiece of a particular political party.
So you have said that you have pleaded that they have only published notice through Ganashakti,
Right.
none other else.
And another one, Asian Age. The real state is this. My learned friend possibly were residing there. At that point of time, 2% people had no knowledge whatsoever to go through English newspaper, Asian Age. Asian Age. So our contention is the intention of the government is to allow the person concerned whose land has been acquired and handed over to the requiring body. They should know what exactly real state was. Illiterate people at that point of time, it was there in the year 2000, to the section. Now it is different. This was our first contention. And on this score, they applied section 6. May I read section 6 of the Land Acquisition Act? Goldman.
Yes, proceed.
The declaration that the land is required for public purpose, subject to the provisions of Part 7 of this Act, when the appropriate government is satisfied, after considering the report, if any, made under Section 5A, subsection 2, that made under Section 5A, subsection 2, that any particular land is needed for a public purpose or for a company, a declaration shall be made to that effect under the signature of a secretary to such government or of some officer duly authorized to certify such order. And different declaration may be made from time to time in respect of different parcels of any land covered by the same notification under Section 4, subsection 1, irrespective of whether one report or different report has to have been made, whichever required under section 5A, subsection 2. Provided that no declaration in respect of any particular land covered by a notification under section 4, subsection 1, published after the commencement of the Land Acquisition, Amendment and Validation Ordinance 1965, but before the commencement of the Land Acquisition Amendment Act 1984 shall be made after the expiry of 3 years from the date of publication of the notification. Or II, published after the commencement of the Land Acquisition Amendment Act 1984 shall be made after the expiry of 1 year from the date of the publication of the notification. Provided further that no such declaration shall be made unless the compensation to be awarded for such property is to be paid by the company or wholly or partly out of public revenues or some fund controlled or managed by local authority. 2. Every declaration shall be first published in the official gazette and in 2 daily newspapers circulating in the locality in which the land is situated, of which at least one shall be in the regional language, and the collector shall cause public notice of the substance of such declaration to be given at convenient places in said locality. The last of the dates of such publication and the giving of such public notice being hereinafter referred to as the date of the publication of the declaration, and such declaration shall state the district or other territorial division in which land is situated, the purpose for which it is needed, the approximate area, and where a plan shall have been made of the land and place where such plan may be inspected. 3. Said declaration shall be conclusive evidence. The said declaration shall be conclusive evidence that the land is needed for public purpose or for a company, as the case may be, and after making such declaration, the appropriate government may acquire the land in manner hereinafter appearing. So that's why at the outset why I was submitting before your lordship, my lord, according to section 4, which was not followed by them, and implication of section C. When section 4 was not followed by them, section 6 is certainly fails.
No, so what is the scheme? Scheme is section 4 is the notice.
Section
4 is the notice of acquisition. Section 5 is the
5A.
Section 5A is the objections. If any
No
has to be
objection was whatsoever given to us. My lord, now I am reading 5A. 4, 5A, 6, nothing has been followed.
No, I want to know the scheme. Scheme is publication of preliminary notification for acquisition under section 4. Thereafter, if there is an objection, 5A is the hearing of objection and 6 is the declaration.
Notification, section 4, the initial for the land is needed.
Yes.
In 74 of the particular act, the section 5A is the difference with
Emergency provisions.
emergency provision. Lordship, the first the notification was come out in the paper, which was from 17.
That is 17. Emergency provisions.
17.
So in this case, the emergency provision is imposed.
For the High Court plan is there, and the number 1, Lordship, all the substance of the notice must be published in the Calcutta Gazette, and that Calcutta Gazette publication will be circulated in the locality in 5 conspicuous places like school, Gram Panchayat office, BDO office, and other public places, for knowing the people at large that the land is acquired in that area, and that was the rumor in the date of the date. Each and every person, they may knowing person, not knowing person, but they notice the land is going to be acquired by the government for public consequences. All such things was published in the locality. So it is not the fact that has not been done. Similarly, section 6, the declaration of lordship, land is needed and the declaration three months things, gazette notification, publication, paper publication, and section 6 places that publication will be circulated. And this is the theme of the Land Acquisition Act. And lordship is not the case, lordship, and publication all such things must be their lordship. Otherwise, inter-acquisition is totally bad lordship. It is not possible. It is not possible to acquire the land. All such things has been done in this case. That is why, lordship, they have asked for amendment in the writ code, which was turned down, and there is no appeal against that. That is the case.
So they have filed the writ petition that the notice under section challenging 4 and 6. Actually,
4 means 4.
4 and 6. And
Only 4.
but the provision has adopted in the acquisition process that the 17.
And lordship,
17.
all the provision, yes, lordship, all the provision of law have been totally followed by the land acquisition collector, and at the time of notification, publication of notification, section 6 declaration, section 9 notice to the land user, and there are section 11 lordship from publication of the award, and section 6 position was taken. This is the provision, total provision of the land acquisition.
Yes.
Lordship knows it.
No, so that is not the issue. Issue is that, so what happened here? 17.
No, it's not 4 is yeah, A lordship, that is the only player.
No. 17A, that is the next in the paper book 204. These are afterthoughts. What they say, government required. I have not seen a single government officer he has told before the public, I have committed a wrong.
Only the player is.
I have committed wrong. Not a single officer I have seen ever. This is their plea. Our saying is this. Section 17 was not followed. The cardinal principle should be, they should have followed 5A of the Acquisition Act. I have not given you opportunity of hearing. Their story is all the way telling, as two senior Banerjees are all along telling, the supplementary application has been dismissed. No doubt about that. There might have some wrong. I am not questioning this. But in my writ application, I categorically, awarding the writ application, subsequently paid before the writ application, that section 4, the notification is bad in law. Section 17 was bad in law. 74. Milord, for your ready reference, once again I am 5A. The principle should be followed. No time in the world it was followed by them. But hearsay, whenever I file writ application, these are afterthoughts. These are afterthoughts. Let them say, school, etc., etc. Notification was pasted. I am not in the know. I do not know. But for your hearing of objection.
So whether you have made objection?
No. Scope. I had no scope of even to 10.
Then why you
my matter is there. 17.5, 17.4, what my learned friend is saying, absolutely vague. They have not followed. I am fortified with some judgment of the Supreme Court different time. There was no earthly reason at that point that government would apply 74. No earthly reason. In case of a city or a town or a particular development of a place, the application of 74 does not hold good. The Supreme Court in different cases has come to conclusion.
No, that is not your
in
prayer.
case of urgency.
Now, whether you have prayed that the urgency provision has not been interpreted here?
I have prayed with, this is my prayer also. আমি দেখিয়েছি, তুমি দেরি করে এসেছো। প্যারাগ্রাফ 15, as I categorically submitted before a counsel, your petitioner states that the respondents are trying to evade the principles and procedure prescribed under law. It may not be. It's up to court. It may not be mentioned 17(1), but fact remains. We say enter procedural is bad. That's why under section 4(1), under section 6 was published or served in accordance with the provision law, namely Act of 1 of 1894, accepting some notice publishing Ganashakti dated 21/11/2022 is categorically as stated.
Where is the notice?
Notice page 204. 204 to 208. All Bengalis. (204) যেহেতু রাজ্য, may I read?
Yes.
21/11 যেহেতু রাজ্যপালের এরূপ প্রতীত হইয়াছে যে যাত্রাগাছি গ্রামের জমির, দেখেছি আমি, জমির শাস্ত্রের ক্ষেত্রাধিকার তালিকা নম্বর 24 পরগনা রাজারহাট পরগনা জেলা উত্তর 24 পরগনা, যেহেতু রাজ্যপালের এরূপ প্রতীতি হইয়াছে যে জনস্বার্থ তথা রাজারহাট উপনগরী নির্মাণ প্রকারে প্রয়োজন হইতে পারে, অতএব এত দ্বারা প্রকাশিত হইল যে নিম্নের তফসিল বিবৃতি ও পরিমাপিত সর্বমোট কম বেশি 02858 হেক্টর 070 একর জমি সহ উপরোক্ত গ্রামের মধ্যে সরকারি ব্যয়ে উপরোক্ত জনস্বার্থ প্রয়োজন হইতে পারে। এই প্রজ্ঞান 18/134 এক আইনের 1814 এর এক আইনের 4 রাজার বিধান অনুযায়ী সংশ্লিষ্ট সকলের প্রতি প্রদত্ত হইল। এই জমির একটি নকশা বারাসতস্থ উত্তর 24 পরগনা আধিকারিকের অফিসে দেখা যাইতে পারিবে। উপরোক্ত ধারার অর্পিত ক্ষমতা প্রয়োজনে রাজ্যপাল উদ্যোগ চিতে তৎসময়ে কর্মরত আধিকারিকগণকে তাহাদের কর্মচারী ও শ্রমিকগণস্থ জমিতে প্রবেশ জরিপ ওই ধারার অনুজ্ঞত এবং অনুমতি অন্য সকল কার্য করিতে প্রাধিকৃত করিতেছেন। 1814 এক আইনের 17(4) ধারায় অর্পিত ক্ষমতা প্রয়োগক্রমে রাজ্যপাল নির্দেশ দিয়েছেন যে নিম্নের তফসিল বিবৃত জমির ক্ষেত্রে রাজ্যপালের মতো 17(1) ধারার বর্ণিত বিধান প্রযোজ্য হওয়ায় উপরোক্ত আইনের 5(1) ধারার অর্পিত বিধান প্রযোজ্য নয়। According to them, this is urgent. That's why in case of urgency, in case of development of the state, in case of development of the requiring authority, no need of applying section 5(a). All the way we are harping for it. Jatra Mougagachi Khetatika Disati. These are notification 4 to 8. This is the subject matter of challenge. Yes, it is seen that in the prayer we have not specifically mentioned section 4, section 6 or 17(1), but it is clear aberrament is there. Madam, please see for your 7(5) hearing of objection of the Land Acquisition Act 1894. Any person interested in any land which has been notified under section 4, subsection 1, as being needed or likely to be needed for a public purpose or
You
for
are
a
reading, section 17, subsection 5.
5(a). I mean 5(a), all opportunity to hearing should be given to the persons whose land would be acquired by the state. It has not been done so. That's why, for your kind response, I am just
No. Section 5A is the hearing of objections.
Hearing of, but that was not given to us. 17.1, they applied.
Whether you made any objection,
We had no scope because
then there is no
according
scope.
to us, Section 4 notification, it was not properly notified. We are not in the know.
No, it was notified
Still-
under section 17, not 4. First 4.
But first 4, then 17.1, first 4, they have not a single notification.
Where is the section notice under section 4?
Section 4 daily newspaper that should be published. That was, as I read,
What you referred?
yes,
This is 17.4.
17.4, that is page 204, the notification,
17.4 for dispense with section 5 of
5 objection.
that has not. Page 1 and 4.
Page 204.
আইনের ধারা 4.1 যুক্ত হইল 4.1
Okay, 4.1 notice under section 4.1. Okay. Now I understand.
It's a big project, not it? A big project of more than 10,000 acres. More than that. Like Delhi Airport, Noida, Newtown, all of the same. That is why, Lordship, identity commission was out. By way of the 5A. Thereafter, all other commissions have been totally followed. Section 4, they've been 17, section 4, section 5, section 6, section 7, 9, 11, all such commissions followed. That is why, Lordship, there is no scope or there is no lacuna in the provision of the law. There is no invocation of the law.
The provision is very clear. Have they followed? The burning questions. I am trying for it for 20 years. Now I am also. Mother, please cease. Next para, 1894 এক আইনের 17 ধারার অর্পিত ক্ষমতা প্রয়োগক্রমে রাজ্যপাল। বাংলায় মুশকিল হয়। Fact remains, whenever section 4 was not properly followed, according to us, 17.4 cannot be impeded.
Where is the what is the ground not employed?
Madam says, on what basis? A big city will not do. In case of Supreme Court in several judgments, according to us, this is the crux of the matter, my lord. I may cut short it.
Okay, I understand. I understand your submission. So your submission is they have followed the provision after serving notice under section 4. They directly, according to the power under section 17.4,
Right.
they waived your opportunity of hearing under section capital 5A.
Right.
This
It
is
does not
your
hold
grievance. This is your grievance.
Rightly.
There is no such emergency case, no such provision.
Exactly.
How the government can follow such provision.
Rightly.
So this is arbitrary. So
And even to that extent, I beseech your lordship, my learned friend and both senior Banerjees are advocating in favor of required authority, not for state. State has a pivotal role.
state is the answering response.
No, state is not appearing. State has to protest records. Until and unless record is produced by state. Hearing, I do feel sometimes it may be even misnomer.
Whether that is.
Whether affidavit placed by the government, whether government placed affidavit in opposition?
No, there was there was specific, no, sometime in the next, last occasion, possibly before when it was heard by Justice George and Gupta in that building below, state was directed to file every, Mr. Pal, Chondi Charan. I even talked to Mr. Chondi Charan, yes, I would appear in the matter. You know, state has a pivotal role. They are requiring authority. They are the child of the state.
The recording authority only raised the proposal and the fund placed to the LA collector. The land is required for construction of the big town.
No, it is correct that the action under LA Act, that is the acquisition, has to be done by the state. Thereafter, they will hand over to you.
Right.
This is the provision.
But if the land has not been handed over, I have not served notice. There are some other questions. And at that point of arose.
Let me understand your submission first. You have said the invocation of section 17(4) is arbitrary.
Yes.
So why? What
This
is
is
the
not urgency clause as specified in 17(4) as I
17(4)?
reading below 17. This is not an urgent issue. Since inception, it was our submission.
Yes, let's we read the 17.
17. Special powers in case of urgency. It's a special power. In case of urgency, in cases of urgency, whenever the appropriate government so directs the collector, though no such award has been made, may on the expiration of 15 days from the publication of the notice mentioned in section 9.
No, that is 17(1).
Yes,
Psalm 17(4).
and take 17(1) to consequently subtime question. That's why I'm reading below. It may arise. That's why. Free from all encumbrances, 17(4).
17(4).
Two, Milord, owing to sudden change. Whenever owing to sudden change in the channel of any navigable river or other unforeseen emergency.
No, these are the circumstances which was mentioned in section 17. And section 17(4) has invoked here.
Even
So, what is the provision?
17(4). Milord, according to me, the section 17(1) is applied. The question that arises of urgency provision. That's why only 17(4). In the case of any land to which, in the opinion of the appropriate government, the provision of subsection 1 or subsection 2 are applicable.
Yes.
To as a question of urgency.
Yes.
The appropriate government may direct that the provisions of section 5A shall not apply.
So when where the cases subsection 1 and section 2 is applicable, at that case the appropriate government may direct the provision of section 5A.
Yes.
So what are the cases?
Two. For it by kind information.
Yes.
Without I'm again reading 2. Whenever owing to any sudden change in the channel of any navigable river or other unforeseen emergency, it became necessary for any railway administration to acquire the immediate possession of any land for the maintenance of their traffic or for the purpose of making thereon a riverside or ghat station, or of providing convenient connection with or access to any such station, or the appropriate government considered it necessary to adequate the immediate possession of any land for the purpose of maintaining any structure or system pertaining to irrigation, water supply, drainage, road communication, or electricity. The collector may immediately, after the publication of the notice mentioned in subsection 1, and with the previous sanction of the appropriate government, enter upon and take possession of such land, which shall thereupon based absolutely in the government, free from all encumbrances, provided that the collector shall not take possession of any building or part of a building under this subsection without giving to the occupier thereof at least 48 hours notice to his intention to do so, or such longer notice as may be reasonably sufficient to enable such occupier to remove his movable property from such building without unnecessary inconvenience.
For the purpose of the township, that cannot.
So that's why, to start with, it was my submission, although I am choosing that road, the notification issued by the government, I mean, for the purpose of, as notification says, that page 204 or 206, it will be same. জনস্বার্থে তথা রাজারহাট উপনগরী নির্মাণ প্রকারে প্রয়োজন হইবে। In উপনগরী নির্মাণ is not a matter of 6 months, 10 months. It takes even to the extent of 8 years, 5 years, 10 years. Now Rajarhat is completely different after 20 years or so. But at this stage, a portion. And
Not all.
and even to that extent, it was my submission at that point of time, there was no scope, and state arbitrarily applied section 4, section 174 of the Land Acquisition Act. And it was by the state. Late has not canvassed it categorically and bestowed responsibility upon the required authority. Required authority. But fact remains, our contention, all this notification as issued by the government is bad in law. And
So whether state has discretion to declare any land to be possessed or acquired in emergency basis.
right, state can do,
Yes.
but state has to do
According to
following all corners
according to
of the law.
Yes.
And they have to follow section 4, section 6, 17.1, 17.4.
So this is your submission that the acquisition process was done not according to the law.
Not at all. Both these matters, even to that extent, last occasion, possibly it was at the time of hearing before court number 652 or like that, Mr. Patnaik asked the state government to produce a list they have acquired land. You know, sometimes these poor, not poor, I would say, educationally poor people, if I say so, they could not place their case before the government when notifications were issued subsequently. You know, that's why the Honorable Court at this point of time asked Mr. Chandicharan De, senior advocate appeared, Alaguchi Junior. Even I told Mr. Desabde 2-3 days back, he told me that he would appear.
Well,
A list. And real estate would come to me if the list is for the people by lordship.
So this is the only gist of the matter. This is the only gist of the matter.
Yes, sir.
So what document you have placed? Why so much voluminous paper?
Milord, so voluminous document. Milord,
There is a sale deeds and everything.
sale deed records is 400 pages.
Records and sale deeds
Pages.
of the petition.
But the documents, the record holder is no other than state. And I believe requiring authority can well assist state.
state should be come forward.
And it is the duty of the state to come forward. My lord, to justify my end, Milord, I would on next topic, sir, Milord, if I've been given a scope, I'll produce some judgments of the apex.
You
court.
place the judgments today? What
It
are the
is-
judgments? When?
Milord,
What is the scope? What is the
Milord,
ambit of the state to
yeah,
declare
Milord,
emergency
this
provision?
is not one, this is also voluminous. Just a bit, that's why. That's why. Milord, I was in a very mental state of anxiety, Milord. My client would have been to that house in a contempt proceedings, Milord. Personal appearance. That's why earlier I mean, at the morning I told my senior friend that matter would be there. At my court number 14, Milord.
Okay,
Milord, I'll certainly. I've all
very
two
good.
copies.
Let me settle out this matter. I am directing you to serve notice of the next date to the state.
State.
You serve notice. Please take down. Argument, HIDCO is the respondent number.
Eight.
Respondent number 8. Respondent number 8. Okay. Respondent number 8 is represented to Learned Counsel, Mr. Banerjee. Mr. Ashok Kumar Banerjee. Mr. Ashok Kumar Banerjee. Full stop. Argument on behalf of the petitioner continues. No representation is made on behalf of the state authority. It appears that without presence of the state authority, the matter cannot be heard out effectively. The accordingly, petitioner is directed to serve the notice upon the Learned Counsel appearing on behalf of the state authority, informing them that the matter shall appear in the list on 12th of August 2025 at 2 p.m.
At 2. Hey, 12.
Petitioner shall submit a affidavit of service on the adjourned date.
What a tutuling. Milord, is it parted?
Of course. For your benefit.
Always be beneficial.
But there is another matter.
On their keep.
Same order.
Similar order, similar.
On their kiba din kiba rati. Apnar ichu.
Rise now.
Yes. Yes. For both the matters. 2 p.m. Both the matters 2 p.m.
খুব ভালো জিনিস। আবার আছে
Most of the benches rise 10:45, except me. All the benches rise 10:45, except me. I rise too. Thank you.